And there I am. And welcome, everybody. Welcome to the Law of Self-Defense. Day 3 of the Karen Reed murder retrial. We're just a few minutes before the trial starts, so I can have a moment to pull up a live stream for Day 3. Let's see. I am, of course, attorney Andrew Branca for the Law of Self-Defense, and we will be joined by my friend Nick Rekieta of Rekieta Law. He'll be streaming to his audience on YouTube and Rumble. I'll be streaming to my audience on YouTube and my lawofselfdefense.com member site, but we'll be doing it together. Let's see. There's Court TV, Day 3. Get that pulled up so I know we have at least something to work with. Whoops. Let's see. And at the end of each day, I'm going to be doing a brief summary, a 10 to 20 minute summary of the day's proceedings as well. Let's see. All right, so at least we have the Court TV feed. So if you can't join us for the whole day, which I certainly understand, you can join me for that 10 to 20 minute summary of the day. I take up to generally about 40 pages of notes each day and share those with you when we get to the end of the day to get a quick recap. The story here, of course, is Karen Reed is charged with murder and various other charges for the death of her police officer boyfriend, John O'Keefe. They were at a house party during a Boston blizzard. Police say she sped out of the driveway, struck him with her car, and drove away, leaving him to die in the snow. Defense says nothing like that happened. There was never any collision. Meanwhile, of course, she's being tried for second-degree murder, manslaughter while operating a vehicle under the influence. She was certainly drunk, and leaving the scene of a collision resulting in death. This is a retrial. She was tried for these crimes a year ago with the same legal team she has now, a legal defense team, and it ended up in a hung jury. They could not arrive at a unanimous verdict, so that case was dismissed, and the prosecution brought the charges again for this second trial, and now she has the same legal team. Very good legal team, by the way. I'm told they're all working now for free. Both her 4 or 5 attorneys are working for free, and apparently there's a bunch of law school academics and students who are also contributing to her defense, all pro bono, which doesn't surprise me. This would be a multi-million-dollar defense. Someone reported yesterday that she was, in fact, several $1,000,000 in debt already. But that's what a good defense costs, folks. That's what a good defense costs. So, we're back with the ceiling fan. I guess I'll take that down. There's Nick. He's not quite with us yet, but I expect will be with us soon. I do ask if you'd be willing. We here at Law of Self-Defense are on a mission to hit 1 million subscribers. We get a little bit closer every day. Got a little bit closer yesterday. We broke 197,000 subscribers yesterday. And I'd love to break 198,000 today. So if you're watching on Nick's channels, Rekieta Law on YouTube and Rumble, you should continue doing that. But maybe pop over to my YouTube channel at Law of Self-Defense and just smash that subscribe button like the prosecutor says Karen Reed smashed John O'Keefe into the snowbank to die, and hit that thumbs up like button as well. Let's get Andrew. Let's get law of self-defense to 198, 19.8% of the way to my goal today. And we'll continue pushing forward a little bit at a time with your support. Also, hit that thumbs up like button, because that's what tells the YouTube algorithm to share our content more broadly. And that's how you really expand your audience. It's not just what you do, it's what YouTube decides to do with your content. So that would be of great help. Yes, I'll be asking many times, every break the court takes, I'll be asking you to please, in fact, let me pin the comments. Subscribe, subscribe, subscribe. That's the best thing you can do to help us out if you like our content. And of course, you should naturally also subscribe to Nick's channel. I'm sure Nick would appreciate that as well. Let's see. Put a couple little fire things in there. Emojis. I'm learning how to use emojis because I'm a master at YouTube production stuff. All right. 6:57, court scheduled to start in 3 days. So what's been happening? We've had a few witnesses so far. Let me get my notes here in order. I think we're on our 5th witness. The first witness was a EMS guy, Timothy Nuttall. Did a lot of in his responses. His big pitch for the defense, and of course, this is the for the state. This is the state presenting its case in chief still. So these are all state witnesses. Timothy Nuttall reported that when he was at the scene providing aid to John O'Keefe, he asked Karen Reed, "Do you know who this person is?" And Karen Reed told him, "I hit him, I hit him, I hit him." He was not a very good witness. His memory was not very good. He appeared to be not very cooperative with the defense on cross-examination. It was a bad look. By the way, the state opening, I posted that up separately on my YouTube channel. You can see that. It was technically solid. It was theatrically poor. It was very flat, monotone, not very compelling. The defense opening was done by defense attorney Alan Jackson. It was great. So you should definitely watch that one. After the openings, we got to Timothy Nuttall. Then we got to Kerry Roberts. Kerry Roberts was a friend of John O'Keefe's. She was involved in the search for his body along with Karen Reed that evening. After Karen says, "I dropped him at the party house and he hasn't come home 5 hours later. I'm worried about him. Let's go search for him." Ultimately, they end up back at the scene of the house party and they find John O'Keefe's body in the snow. Kerry Roberts obviously does not like Karen Reed very much. And testified accordingly in a very negative way about Karen Reed. In particular, on cross-examination, we learned that Kerry Roberts had previously testified that she overheard Karen Reed telling someone to Google hypothermia and how long it takes someone to die under hypothermia, which would be pretty bad. Pretty bad. That would not be a good thing. Hey, man.
I'm moving like an 80s computer animation on my screen. Is it really choppy and broken up on yours? Like, am I dashing around?
Yes,
camera?
It is.
Okay. Looks like I gotta do a quick reboot, but I'll be right back, and then I'll jump right back on. Sorry about that.
All right. So Kerry Roberts had previously testified that she had overheard Karen Reed asking someone to do a search on hypothermia, how long it takes someone to die, which would look pretty bad for Karen Reed. Except it turns out on cross-examination that, in fact, and that Google search was made. It was made on the phone of another woman who was present at the scene of the body discovery, Jen McCabe. But they don't want to, the state doesn't want it pinned on Jen McCabe. They want it pinned on Karen Reed. So although Jen McCabe did the search, they're trying to say that she only did the search because defendant Karen Reed asked her to. In fact, on cross-examination, this witness, Kerry Roberts, had to concede that she, in fact, had never heard Karen Reed ask for that Google search. Pretty good day for the defense. That was actually on the second day of the trial yesterday. Kerry Roberts was still on direct at the end of the first day. Court recessed, and we came back on the second day where direct of Kerry Roberts continued, and then we had the cross-examination of Kerry Roberts I just described. Then Peggy O'Keefe John O'Keefe's elderly mother came to the witness stand, very teary-eyed, as you might imagine. This is not the first adult child that she's lost. She also did not like Karen Reed, very unfavorable opinions. When it came to cross-examination, defense attorney Alan Jackson was very savvy here. He could have said, we just have no questions for Peggy O'Keefe, John's mother, which is the smart play, not to have any questions for her. There's not much you're going to gain from cross-examining the weeping mother of the victim here. But instead, he went to the lectern and simply said, we're very sorry for your loss. We have no questions for you. And I thought that was a very classy way to do all that. Just waiting for Tim, oh my God, for Nick to hop back in. Then the next witness after mom Peggy O'Keefe was Nicholas Guarino, Massachusetts State Police, cellular forensics, very dry. He just described how he did the Celebrite extractions of various phones. It wasn't really substantive testimony. He is subject to recall, so I expect we'll see him again to give more substantive testimony. And then we got to Daniel Whitley, a Canton Fire Department, whose testimony was very infuriating because he started every sentence on the direct examination with yes, no, this is what happened. Curiously, on cross-examination, he lost the uhs. I had the sense that he was uhing on direct because he had a script he intended to follow. And so he had to recall the correct portion of the script to know what to say. He was not very compelling. He was negative about Karen Reed, very much a friend of Kerry Roberts. He lived a couple hundred yards away from her around the corner, same neighborhood Facebook group. All of them were friends with John O'Keefe. It's very much an in-group of people. And then Karen Reed, although she was John O'Keefe's girlfriend, was not part of this in-group, which is part of the dynamic of this trial. So far for the prosecution, we've only heard from prosecutor Hank Brennan. He did the opening statement. He's been doing all the direct examination. There is another prosecutor, Adam Lally, involved in the first trial as well. We've not yet heard from him. Defense attorneys we've heard from are Alan Jackson. Whoops, here we go.
Just in time.
Just in time.
I love it. I'm like, I'm going to be on time today. And of course I get here on time and OBS was just going.
One brief issue I want to raise for the court.
Okay.
I wanted to confirm whether experts in this case are permitted to watch testimony in order to prepare for rebuttal. We'd ask for that.
For rebuttal, like post
Responding,
for responding. Okay.
in our case, for both sides.
Okay. What's your position? Ms. Little, you want to?
Yes, we can.
All right. Mr.
So
Brennan,
can
is there any
experts
reason not
listen to
to?
testimony?
I need to give it some thought. I'm not willing to. I'll abide by whatever the court thinks is fair.
So
I
why
haven't
don't
given-
you think about it? We'll address it later today. Okay. There's no expert testimony today, right?
It's not.
Okay.
Thank you.
All right. Sure. Is that it? Ready to bring the jury in?
That's all.
You wanted a ruling on the clip from yesterday?
I did.
All right. You can play it.
Thank you.
All right. So
Oh,
we'll
see?
take a
No
quick-
argument about consciousness of guilt. Clip is in.
Yep.
The clip is in.
I think this is a big miss. Honestly, I wanted to do a video on it yesterday, but I got Wednesdays are just rough on the kids have stuff going all the way through the evening. But I wanted to do a video on it yesterday. What for those of you who may not remember, yesterday there's a video clip or two video clips that were proposed by the prosecution. The defense did not object to the first video clip. The defense did object to the second video clip. The prosecution, however, was allowed to provide minutes and minutes of exposition about how these video clips proved something that they don't purport to be in any way, which is consciousness of guilt on behalf of, or on the part of Karen Reed. Consciousness of guilt being extremely venomous to a defense because the prosecution gets to basically tell the jury that this video is evidence directly that not only did Karen Reed do it, but she's conscious of the fact that she did it. And the statements that they're about to see are evidence that she is guilty in her own mind and presenting that to you. And just think of how it's presented in title. Titles are very important. They're catchy. They're things that we remember. Consciousness of guilt could be said to the jury very specifically. And actually, the prosecution laid out exactly how they intend to do that on cross, in front of the defense, in front of the judge. And now these clips are in, which means that on their, I said on cross, on closing arguments, they will be able to refer back to these clips, which the jurors probably will not remember, talk about Karen Reed removing the murder weapon from the scene, which is how they describe the car, but they call it the murder weapon. Consciously removing the murder weapon from the scene and bringing it elsewhere because she is conscious of her own guilt and how the murder weapon will look when investigators show up to see it. That is an insane thing to not object to as the defense, because that is how the prosecution intends to talk about this at close. And if they missed that and try and object to it on closing remarks, they're going to get excoriated by the judge, and they will be overruled under pretty much any circumstance I can imagine. I don't see why the judge would, at the 11th hour, decide that the prosecution can't make that argument in regards to these clips, when all of it came in over without objection on the first clip. And on the second clip, the judge has clearly ruled in their favor. And the only argument that the defense came up with was, well, these make our client look bad. And that's why they're playing this clip, is to make our client look bad. And Alan Jackson has been a great attorney. Please do not mistake me as criticizing him unfairly or saying he's bad in general. It was just a bad thing to miss. All evidence that's bad for your client makes them look bad. Like, I just can't get over enough how bad of an argument that was. I don't know what they were doing. It's like it went right over their heads that this is happening, but it seemed pretty obvious.
Hear ye, hear ye, hear ye. All
Hear ye.
persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
22117, the Commonwealth versus Karen Reed.
All right. Good morning again, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same three questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, and read anything about this case since we left here yesterday? No. Everyone said no or should be. Thank you very much. Will we bring Mr. Whitley back in, please? Ms. Tianetti, you can step up to the podium.
I just realized I did not have Rumble going live, but we are up now over on Rumble.
Next witness. Witness number 6.
Why would the
Sir,
defense
you're still under oath. Thank you.
not
Oh, no, we're
object to
still with
anything?
Or
Not
Daniel Whitley,
oops.
Canton Fire Department.
I've lost track of
Yesterday,
which
you testified
I'm
that when
sleeping with
Karen
now.
Reed was brought to the hospital, she didn't want to get into a hospital Johnny, and she didn't want to give a urine sample. Do you recall that testimony?
I do.
It was clear to you that her reluctance to cooperate at that time was because she very much wanted to check on John's progress and status at the hospital, correct?
No, I don't believe that to be the case.
Well, you testified before the grand jury regarding this matter 3 years ago, didn't you?
This is cross-examination.
I don't believe I said that
I
she
gave
was
it-
the
I
didn't
didn't ask you that
Yes.
question. You testified before the grand jury 3 years ago, didn't you?
I testified before the grand jury 3 years ago.
You were under oath then, as you're under oath today, correct?
Correct.
You swore to tell the truth.
I am telling the truth.
You swore to tell the truth in 2022 before the grand jury, did you not?
I did.
That was less than 3 months after you brought Karen Reed to the hospital, didn't you?
Yeah.
And your memory of what happened at the hospital was very good in April of 2022, right?
As good as today.
Your memory in April of 2022 was very good, wasn't it?
It was very good as it is today.
Okay, so you want to add the as it is today, despite the fact that you weren't asked that question. Is that right?
Objection.
Sustained.
All right. When questioned by
All
Mr.
right.
Lally at the grand jury, you were asked the following question. So what, if any, interaction did you have with her, meaning Ms. Reed, at the hospital once you were there? You remember that question, right?
I do.
And your answer was, so we, after that, I helped escort her down to, they call it the psych hallway, where they have rooms set up for psychiatric patients for their evaluation. And then she was unhappy that she wasn't able to see him, meaning John. And she kept trying to. She didn't want to get into a hospital Johnny. She didn't want to, I believe, give a urine sample. She was not, the nurses were asking her to do certain things that every patient has to do, and she was not cooperating with them. Do you remember that answer?
I do.
So 3 years ago, when you testified about this issue of giving a urine sample, you testified under oath that you believed that she didn't want to give a urine sample, correct?
Correct.
Yesterday, 3 years later, you testified with certainty that she didn't want to give them, right?
Yeah, she was giving them a hard time about having to give a urine sample.
Right. No, I'm asking you about your testimony yesterday in contrast to the grand jury, sir.
Okay.
To the extent that I ask yes or no question, I'd like yes or no answers.
So
okay?
no instructions to the witness, Ms.
Your
Giannetti.
Honor,
Ask
may
a
the witness be
question.
instructed to answer the question yes or no if it calls for a yes or no question. Answer.
Answer the question that's asked of you, okay?
Okay.
She
So go
won't
ahead,
even
ask
just
the
give him the
question.
basic instruction.
You testified yesterday that she didn't want to give a urine sample without saying it was your belief that she didn't want to give one, correct?
Correct.
In any case, were you aware that when she was asked to give a urine sample, that Ms. Reed had gotten her period and did not have a tampon?
I was aware she was on her period, yes.
You're also aware that when somebody is brought to the hospital for a Section 12, they have no privacy. Isn't that right?
They have medical privacy. Either the tech or the nurse would be with the patient at all times.
Okay. With them at all times, observing them at all times,
correct.
correct?
So they wouldn't be, she wasn't in like a hallway open to the public.
Understood, sir. But she also, when I said privacy, what I was asking is, she was not allowed to go to the bathroom alone to give a urine sample, correct?
She was a psychiatric patient.
Right. So she would have to use the bathroom in front of hospital personnel or some medical personnel with people watching her while she was on her period with no tampon, correct?
I would understand that to be true.
All right. And you're aware that she did cooperate and eventually give a blood sample as well, correct?
I'm not aware of a blood sample, but urine sample, yes.
She
You
did
can't
give a
put those
urine
two
sample.
questions
Correct.
next to each other.
Now,
You
in your
cannot do
testimony
that.
yesterday, you discussed the topic of your memory of what Karen Reed may have asked you about John surviving in the snow with light clothing. You remember those questions?
I remember asking about not having a jacket, correct?
Now, starting at the end of the day, when I cross-examined you yesterday, I asked you about that topic, and I said to you, you mentioned something about hypothermia, that you assumed you may have been dealing with a hypothermia situation. And your answer was, well, she said that he had been out in the snow without a jacket for many hours, correct?
Correct.
But before I cross-examined you at the end of the day yesterday, you previously testified 3 times about this topic, correct?
I believe it would be the grand jury and the previous trial.
Right, and direct examination when Mr. Brennan was asking you questions before I stood up, correct?
Okay, yes.
Let's start with the first time you testified about this topic back in 2022. That was, again, less than 3 months after you had a conversation with Ms. Reed at the scene on January 29th, correct?
Correct.
Her statements and questions to you at the scene were fresh in your mind in April of 2022, correct?
Correct.
In April of 2022, before the grand jury, Mr. Lally asked you, quote, what, if any, questions did she ask you regarding hypothermia? Do you remember that question?
I do.
Your answer was, she was just wondering if he could have survived outside in the cold, even though he didn't have a jacket on. Do you remember giving that answer?
I do.
Nowhere in that answer, in 2022, less than 3 months after these events, do you attribute the words, quote, many hours, end quote, in the snow to Ms. Reed, correct?
Yes, I was not.
I'm not asking for an explanation, sir. I'm asking for an answer.
All right, so he was answering you, Mr.
My
Yannetti.
question called for a yes or no answer. Nowhere in your answer in 2022 do you attribute the words many hours in the snow to Ms. Reed, yes or no?
No, I did not say that at that point.
Nowhere in your answer in 2022 do you testify that Ms. Reed told you he had actually been in the snow for many hours, correct?
She did. At that-
Sir, I'm asking you about your testimony.
I object.
So let him answer the question.
Let me ask it again. Nowhere in your answer in 2022 did you testify that Ms. Reed told you he had actually been in the snow for many hours, correct?
In 2022, I testified that I was just told to be brief and give generalizations. She quantified many hours in the snow when we were back at the
Let
ambulance.
me try this again,
So,
sir. because
Mr.
I-
Yannetti, you're just saying 2022. Get to a
Of
date
course,
and a
yes.
place.
April of 2022.
Wait, was he
Okay,
asked these
before
questions
the
at a
grand
different
jury.
time in
My
2022?
question again, and
He's
I'm
not
still
an
seeking
idiot.
a yes or no
he
answer
is,
from
but-
you. Okay? Nowhere in your answer in April of 2022, before the grand jury, did you testify under oath that Ms. Reed told you that John had actually been in the snow for many hours, correct?
Not in 2022 of April, no.
Okay. The next time you testified under oath was last year in 2024, correct?
So combative.
During that testimony,
Just
Mr.
answer the
Lally
question.
asked you, oh, by the way, so 2022 is no mention of many hours, right?
I did not, and I was told to be brief on the grand jury stand.
But again, no mention of
Right.
many hours in 2022. Okay. Now, 2024, last year, Mr. Lally asked you, so firefighter Whitley, at some point, specific to your conversations with the defendant, Ms. Reed, can you describe sort of her demeanor or any observations you made in relation to that as you were speaking with her? And your answer was, yes, she was very upset. She kept asking if there was any chance. She kept asking us if we knew if the person ambulance 1 had transported was alive or dead, and we could not speak to that. She asked if somebody could be alive in the snow without a jacket for many hours, correct?
Correct.
So 2022, there was no mention of many hours. 2024, over time, now that's the first time that you mention the words many hours in your testimony regarding this case, correct?
Correct.
Right? And when you testified last year, you testified still that she was asking you a question about surviving in the snow, correct?
Correct.
So then we come to yesterday on direct examination. Do you recall that Mr. Brennan yesterday asked you, before you left, were you having any conversations with the defendant? And you answered yes. Recall that yesterday?
Is that at the hospital?
I'm asking you yesterday, do you recall Mr. Brennan asking you before you left essentially the scene, were you having any conversations with the defendant? And your answer was yes.
You're talking about Lee, I'm just trying to make sure we're talking about the same instance. Are we talking about when we left the hospital or when we left Fairview Road?
When you were at Fairview Road, leaving Fairview Road, we're talking about the same subject of what Ms. Reed supposedly told you or asked you. Okay, Mr. Brennan went into that with you.
So on the way to, you're talking on the way to the hospital in terms of left, when we left.
Well, before you left, he meant before you left the scene.
Okay,
When
no,
you
I'm
were-
just trying to clarify.
Again, it's the same conversation, Mr. Whitley. I'm not
So,
trying to trick you.
Mr. Yannetti, he just asked for a point of reference. It's clear. Now go.
He just
Understood.
told You just answered the point of
And
reference.
Mr. Brennan
It's the
said, can
same
you share with the
conversation.
jury what those conversations were about? And your answer was, so we were talking, she was upset. She kept asking if there was any chance her husband could be alive, even sitting outside in the snow without any coat for many hours. Do you recall that answer that you gave yesterday on direct examination?
Yes.
And that was the first time that you mentioned that she said supposedly or asked supposedly about him sitting outside in the snow, correct?
I was just using phrases generally speaking.
Not my question.
I wasn't at that point I was paraphrasing. I was not speaking verbatim to what she said.
Let's try that again. That was the first time that you mentioned that she claimed or asked that he was sitting outside, correct?
It could have been sitting, laying, being.
Let's try it a third time.
So
Was that-
just ask the question, not let's try it.
Sure.
Let's try it.
Was that the first time that you testified under oath that Ms. Reed said or asked about him sitting outside?
Are you asking me to clarify whether she used the
I'm not
word
asking
sitting?
to clarify anything. I'm asking you whether that was the first time yesterday during direct examination that you mentioned that she asked about him sitting outside.
I'm sorry. I am very confused because I'm trying to figure out if he was being outside, sitting outside.
I'm asking you about Ms. Reed's statements, sir. That's all I've been asking you about. Her
Okay.
statements to you and your testimony about her statements to you. Was yesterday on direct examination the first time that you testified under oath that Ms. Reed mentions the words sitting outside?
I don't know.
All right.
I'm just using, she
I'm
might have
sorry.
said laying outside,
Country
being
and
outside, outside.
Okay, so when you testified yesterday before this jury
Yes.
that she mentioned the words sitting outside, you're now saying that that might not have been accurate, correct?
It could have been a different word.
Okay, but you didn't say it could have been a different word yesterday. You just left it as sitting outside, correct?
Yeah, that's
Okay.
what I said, sitting.
All right, so now we get from, the grand jury with many hours mentioned to questions about many hours to sitting outside to let's talk about what you said on cross-examination.
I object.
Okay, the objection sustained.
Sure. On
What's
cross-examination.
the objection?
Your words were, she said he had been out in the snow without a jacket on for many hours, correct?
She had asked if he had been outside, if
Yes
he was,
or
if there
no?
was any chance he could be alive, even though he was outside without a jacket for many hours.
So it always was a question, correct?
It was a question.
She never said what you said on cross-examination yesterday, which was she said that he had been out in the snow without a jacket on for many hours. That was not a declarative statement by Ms. Reed, correct?
Objection.
I'll allow that. Was that a declarative statement by Ms. Reed?
She asked if he could be alive without a jacket in the snow for many hours.
So again, it was a question, sir.
She asked me, and we were just trying to give her hope in terms of telling stories of hypothermic patients who survived outside.
Stop. What's the exposition?
Okay, is there any redirect?
Briefly.
Okay.
You and her were talking. She was upset. I think it's a phrase that describes most of his conversations with women.
When you were called to the grand jury, was the testimony as in-depth and as long as it is in front of this jury?
No, not even close.
When you're recounting your memories of what happened, do you memorize word for word what you've said in the past?
Objection.
As to that form, it's sustained.
When you're recounting the past, do you record your statements personally?
Objection.
I'm going to let that one. Do you record your statements?
No,
Next question.
When you testified in the grand jury, page 90,
No.
line 15, And you said,
Thankfully, the
the
court
defendant
does.
told you, I'm upset if he dies, I want to die. And then you later testify last year, and you said, if my husband dies, I want to die. Do you notice the little differences between those phrases?
I do.
Is that you making up words?
No,
Is that you trying to help a case?
Objection.
That's to form, that's sustained.
Are you inventing facts?
no,
Sir, when you were recounting what happened that day, are you using your best memory?
I would recross this.
When you were asked by the defendant about how long, or someone out in the snow without a jacket for many hours, do you remember that conversation with her?
I do.
Where were you during that conversation?
We were in the back of the ambulance.
Do you remember it distinctly?
I remember it distinctly. She was looking at me.
When you tried to give her hope
Most women don't.
and comfort, and you told her stories about other situations where people, maybe children, have fallen through the ice and had hypothermia, did you have that conversation with her in trying to comfort her?
I did.
Do you remember that conversation?
I do.
Did you necessarily share those conversations with the grand jury?
I don't recall if I did or I didn't.
Did you ever write that in your report?
No,
Is it something you typically put everything in your report?
no, we do not write. Generally, we only write patient complaint, what happened, what they did, not their opinions or anything like that of to what's going on.
Do you have any interest in the outcome of this case?
I do not.
How long have you been a firefighter for?
Since March of 2006 and an EMT since November of 2002.
Over 20 years.
Correct.
You said that you live near Kerry Roberts?
I do.
You've been to a block party for the kids where you've brought the fire engine down?
I do.
Sure, he was asking a question about this career, or maybe it was a
When
different
you're
career
at
that he
that
was
block
talking
party,
about.
do you ever step out and have secret meetings with Kerry Roberts trying to corroborate some conspiracy on their behalf?
No. No.
Put your career on the line? No further questions.
Did you ever commit any crimes with her?
All right, Firefighter Whitley, you are all set, sir.
I don't remember specifically what he said at the beginning of redirect there, but I felt like a little recross might have been helpful. Gosh, I wish I remembered exactly what it was, but the guy was just such an
Like clip
obtuse
5
and
you're on?
difficult witness. You're not going to get anything out of him.
And the judge isn't helpful.
It's like trying to beat a soul out of a government entity.
Defendant's interview with ID docuseries.
And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
That was the second clip from yesterday. That was the point of
All right, who's your
debate
next
in the order
witness,
from this
Mr.
morning.
Brennan?
Next witness is Gene Demoulas.
By the way, if you're watching, anywhere, you can use supertip.gg/Ricada Law or /RL for gems like this.
Your Honor, this witness is retarded because
Okay.
someone banged his mom while she was pregnant with him and dented his skull.
Oh my God, that's terrible. No. Actually, more of that. More of that. I'll try and keep those to times when I know it'll be silent on the screen.
Yeah, no worries.
Thought
Well,
we would
it's
have
easier
one.
to hear it when in those
Right here. Let's one more
Absolutely.
time just for they sent it twice. So I'll play it one more time while we wait.
Your Honor, this witness is retarded because someone banged his mom while she was pregnant with him and dented his skull.
They got it to say retarded. That kills me. Oh.
Hey guys, don't forget to subscribe to Nick and myself on our separate channels. Ricada Law on YouTube and Rumble, and Law of Self-Defense on YouTube. My mission is 1 million subscribers. We broke 197 yesterday. Let's break 198 today. Get a little bit closer every day. That's always appreciated. And it's free. Hit that subscribe button like it's Karen Reed smashing her cop boyfriend John O'Keefe to death in a snow berm.
All it's going to cost you is your time and attention as you're enthralled by the subtle, soft tones of Andrew Branca, explaining the law to you, talking about much more important things than law as well. This man is an expert in the law of self-defense, but this man's opinions on everything are valuable as the gold you would wear around your neck chain if you grew up in Detroit.
All right, next witness, female. Let's see what we got.
It's all choppy.
Good morning.
You can scooch in close to the microphone, thanks.
May I proceed?
Yes.
Good morning.
Good morning.
Could you please introduce yourself to the jury?
My name is Jean Demulis. I am the general manager at CF McCarthy's in Canton.
I'm going to ask you to keep your voice up if you would, please.
Sure.
Thank you.
You said you're the general manager at CF McCarthy's?
In Canton, yes.
Thank you. How long have you been the general manager at CF McCarthy's in Canton for?
For 6 years.
Can you briefly describe for the jury what CF McCarthy's is?
It is a restaurant and bar.
At CF
bar.
McCarthy's, is there a video surveillance system inside?
Yes.
Who owns that video surveillance system?
CF McCarthy's.
Are you familiar with the video system?
Yes.
Have you ever looked at it before?
Yes.
Do you employ people to help the establishment with the video system?
No.
You maintain it on your own?
Yes.
At some point, were you visited by somebody from the Massachusetts State Police?
Yes.
Were you asked whether or not they could view some of your video surveillance?
Yes.
Do you remember the date? Not the date they came to visit you, the date that they were looking for.
I believe it was January 28th, 27th, 28th of 2022.
Around that time?
Yes.
Did you allow access to the video system?
Yes.
Did you oversee that access to the video system?
Yes.
Was it a state police officer?
It was two state police detectives.
Do you remember their names?
I remember one of the detectives' names. I do not remember the other detective.
The one you remember, could you share the name?
It was Detective Buchnick, Yuri.
Detective Yuri Buchnick.
Yes.
At some point, was he allowed to download information from the surveillance system?
Yes.
Did you watch him do that?
Yes, I did.
At some point, have you been able to briefly look at some of that download?
Yes.
And does it appear to be a fair and accurate depiction of the surveillance or the area of your bar?
Yes.
Move to introduce.
Okay, there's no objection, Ms. Giannetti.
There is no objection, Your Honor.
Exhibit 18, so marked.
Thank you.
Your Honor, may I play just a small portion?
Sure.
Thank you. Ma'am, I'm going to show you just some random shots from this video, but I want to know if you recognize it. Is this the inside of CF McCarthy's?
Yes.
I'm not asking if you have any particular knowledge or information about that night. I just want to know is this a fair and accurate depiction of what CF McCarthy's looks like?
Yes.
Has there been any substantive, significant changes to the inside of that establishment
No.
since this video was taken?
No.
Okay. Thank you, Ms. Gilman. Your Honor, I have no further questions.
Okay.
I have no questions.
All right. Mr. Lewis, you're all set.
Thank you.
So there we go.
Just foundational testimony.
The best kind if they can keep it short and sweet. I hate when they have foundational testimony, but they spend a whole bunch of time laying the personal foundation for the witness. They ask them
Where
a
did you
ton
go
of
to
questions.
school?
Your
What was
next
the
witness,
first
Mr.
date?
Brennan.
Thank you. Bridget Meehan.
Bridget Neeham.
Good morning. Good morning.
Everybody's got their own bottle of vodka.
You solemnly swear the evidence you give the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God.
Good morning.
May I proceed?
Yes.
Good morning.
Good morning.
Could you introduce yourself to the jury, please?
My name is Bridget Meehan.
Where do you work?
I work at the Waterfall Bar and Grill in Canton.
The name maybe tells us a little bit about it, but could you just share a couple lines of what the Waterfall Bar and Grill is?
It's a small family-owned
bar
business in Canton.
by the
It's in a
waterfall.
mixed condo complex.
Are you involved in the ownership of it?
Yes.
How long have you been involved with the Waterfall Bar and Grill?
We've been there approximately 10 years.
Do you help run the establishment?
Yes, I do.
And you were running the establishment back on January 28, 2022? At some point, were you asked or visited to see if your establishment had video surveillance of the inside?
I was.
Does your establishment have video surveillance of the inside?
It does.
Do you have a camera and a server?
Do I have? Yes, I do.
Did you provide video surveillance to the Massachusetts State Police from that night, January 28, 2022?
Yes.
May I approach, Your Honor?
Yes.
I'd like to move this in as an exhibit, please.
Okay. Ms. Giannetti?
No objection.
Thank you.
With the court's permission?
Yes.
Thank you.
Quick question from my chat was, what do lawyers take
Ma'am, I'm
notes
going to show you
of
just a brief clip.
when the other side is talking? And I'll address that in just a second. I mean, it's different depending on the situation,
Okay, stop, please.
but
Do you see that video?
I do.
Does that depict the inside of McCarthy's?
No.
I'm sorry, the waterfall?
Yes.
actually, is that even possible to tell? That could be any bar.
Back on January 28, 2022, does that look the way it looked then?
Yes.
Has there been any significant changes inside since then?
No.
Thank you. I have no further questions.
Okay.
No questions.
All right, Ms. Meehan.
Thank you.
So the question is, are they always taking notes? What are they doing? You know, some people doodle to listen. So you have, anywhere from there, like people need to occupy their hands so they can focus
All
their
right, your
mind.
next witness, Mr. Brennan.
Commonwealth calls Mike.
What I was always doing, if there was a witness, or if there was, or if we were arguing in motions, I'm looking for exact quotes, because when I go to counter whatever I'm after, I'm going to use the exact wording. I'm going to call my attention to what they just said, and I'm going to be thinking about how I'm going to respond to that throughout, as I'm listening to the next part of their argument or testimony as well. But it all depends on how people take notes. I mean, some people take expository notes and just are grabbing bullet points that they may want to focus on or address. Maybe something they missed.
morning.
Maybe something they need to research. Can I write in shorthand? No,
Yeah.
do I look like
Please.
Marco Rubio?
Good morning, sir.
Good morning.
Could you please introduce yourself to the jury?
Hi, good morning. My name is Michael Camerano.
He looks terrified to be there.
Camerano, can I ask how old you are? I'm sorry.
Spell your last name.
Camerano.
And so if you could either move the microphone down a little bit or speak up, or maybe a combination of both, please.
Okay.
Thank you.
Thank you. Could I ask you how old you are?
48,
Where do you live?
Canton, Mass.
How long have you lived in Canton for?
Me and my wife have lived there for 20 years. We have 2 children.
How old are your children, sir?
My daughter is 17. My son is 14.
Did you know John O'Keefe?
Yes.
How did you know him?
I met John for the first time at his sister's they had a benefit for his sister in 2013. I met John there for the first time. Then years later, our kids got involved with sports together, and they became very close. As they became close, I became very close with John and his family.
Was your daughter close with John's niece?
Yes.
Was your son close with?
Yes.
Did you spend a lot of time together through sports and socially?
Yes, we did.
I want to take you forward to January
What sport?
28th of 2022.
Okay.
Do you remember that day?
Yes.
Had you, without any discussion of what might have been said, did you have any discussions with John that day?
Yes.
Did you have a plan?
Yes, we were communicating.
At some point, did you decide that you were going to spend some time or go meet John?
Yes. That Friday, my daughter and his daughter, they got acceptance letters to school. So we wanted to get them together so they could enjoy the time together. And, just, go over like how it'll be so much fun, something new, different. Yeah, so we were going to meet up after I got out of work.
Was your daughter planning to go to a new school?
Yes,
Where?
Bishop Fan,
And how about his niece?
same.
They both got accepted to
They
the
both
same
got
school?
accepted to the same school.
Was it a celebratory mood?
Yes,
Did you have a plan to bring the children together so they could celebrate?
yes, we did.
And then separately, you were going to meet John and celebrate?
Correct.
Where did you drop your daughter off?
I dropped my daughter off at John. I went into John's. I was at the house with John and the girls, and we had a little celebration. Talked about how nice it's going to be, fun, change, different, meet new people.
And you celebrated at John's house before you went out?
Correct.
After the celebration with your children, did you and John leave?
Yes.
During that celebration, was there anybody there other than you, John, and your two daughters?
No. No. Karen was not there.
Was there anybody else there?
No, just the two girls, myself and John.
What was the weather like that night?
It was cold. It was not snowing yet.
Was there an expectation? for
Yes,
the
there's an
next morning?
expectation. Yes,
And what was that?
that there was going to be a big snowstorm coming in.
A storm was coming.
Yes.
When you left, did you leave in a separate car than John, or did you leave together?
No, we left together. John got in my car and we were leaving. We're going to leave.
Where were the girls?
The girls are in the house, stayed in the house.
They were staying at John's house?
Yes, correct.
Where did you go?
We went to CF McCarthy's.
When you got there, did you know anybody who was there other than you and John?
At that time, no.
Did you spend time at CF McCarthy's?
Yes.
Were you drinking?
Yes.
Was John drinking?
Yes.
Alcohol?
Yes.
How long were you there for?
A couple hours.
While you were there, did anybody come and meet you that you knew?
Yes.
Who?
A friend. And then Karen came in.
The friend?
Yes.
What was the friend's name?
Kurt.
And then how long after you first got there was it
Still
that
friends?
the defendant arrived?
Just kidding.
I would like to say within an hour, so not 100% sure.
You said back home it was a celebratory mood. Was it still a celebratory mood at McCarthy's?
Yes.
When the defendant arrived, did she spend time with you and John?
I've talked briefly to her, and her and John were mostly talking.
You didn't see any issues?
No.
It was a normal night,
Seemed to be, yes.
as far as you could see.
Yes.
And you saw John drinking.
Yes.
Did you see the defendant drinking?
I saw her with a glass, yes.
Did you leave at the same time that John
That's
left?
Holden. That's
No,
not
I did
drinking.
not.
When you left, was John still at the establishment?
Yes.
When you left, was the defendant still with him?
Yes.
Why did you leave?
I left because I got a phone call. My son was playing hockey in the backyard, and he got hit with a stick and lost his tooth.
Where did you go?
I went to my son's friend's house.
A hockey stick
Do you
or
know
like
about
a
what
different
time that
stick?
was when you went to see your son?
I would like to say 9:30, in between 9:30 and 10.
You didn't go back to McCarthy's that
That'd
night,
be
did you?
hockey in a
No, I did not.
backyard.
After you helped your son,
They
where did
pour
you go
rinks. They put
I
up little
went
borders and fill it
to
with water and make a little
Pick up
skating rink.
my daughter Madeline
I hate Massachusetts.
Did you go?
at John's house.
Did you go in John's house?
No, I did not.
When you got to John's house, did your daughter come out?
No. We went to the side door
Okay.
and rang the doorbell.
And then what happened?
And then my daughter came to the door.
Where'd you go?
From there, we left and went home.
When you went home, had the weather changed at all?
It was cool. It might have been flurrying at that time.
No accumulation?
No.
You got home?
Yes.
Did you do anything significant when you got home?
Put the kids to bed, my son, and no, I went to bed.
What's the next thing you remember happening?
Waking up to, I missed some phone calls.
Who were the missed phone calls from?
From my wife and Karen.
What did you do?
I called my wife.
After speaking to your wife, what did you do?
I got in my car and drove to John's house.
About what time was this?
In between maybe 5 and 6 a.m.
What was your mood at that point?
I was panicked.
Why did you go to John's house?
Because I went to get Kaylee.
Did you know if she was alone?
Yes.
How long did it take you to get to John's house?
Maybe 5-7 minutes.
When you get to John's house, what do you see?
I pull in the driveway. I see that the garage door is open. I go in through the garage door. I don't know if Kaylee was standing there, if the door, she came out the door, and I asked her, if she needed anything, she could get in my car and stay warm.
When you first saw Kaylee, what did she look like?
She looked distraught.
Did you try to help her?
Well, I think I just said everything will be okay. Yeah.
Did she come with you?
Yes.
Where are you going?
To my house.
So what happens?
So we go to my house, and my daughter's up, and the two girls they were hanging downstairs, just hanging out, just being kids. And then, I don't know, a couple hours later, maybe, Paul called me and asked me to bring Kaylee home.
No drug test today.
Did you know
For
anything
me.
at that point?
This guy's going to get
I
him.
did, yes.
You did or didn't?
At that point, I did when Paul had told me.
So what do you do?
Asked Madeline and Kaylee if I'd say, Madeline, we come for the ride. I don't say anything to Kaylee, and we get in the car, and I start heading back to John's house.
And you didn't say anything to Kaylee?
No, I didn't. I just said everything will be all right. She had a feeling.
Why do you say that?
She don't want to go home.
So what happens next?
Somebody coughs.
So I pull in the driveway, and I
want to read this chat by Papa Slapnuts.
Paul and Papa standing. I think they were standing at the side door, and we just embraced.
Did you stay?
No, not long. No.
Did you go back?
I was to the house. I went back to my house.
Did you
Was
go back
embracing
to
your
John's house?
I did the
normal
next day.
activity?
Yes, I was there.
When you went back, were there people there?
Yes,
Many?
there was people coming and going.
Thank you.
I know the one guy in court. I know the one guy who in court who's definitely not the guy coughing. Papa Slapnut. Good Lord. Papa Slapnut says the Southie accent on this dude is palpable. I don't know these New England terms.
Good morning, Mr. Cameron.
Good morning.
This is quite painful for you to remember the events of January 28th, is it not?
This guy's
Yes.
just
You were
a
very
normal guy
close with your friend John O'Keefe, correct?
who's
Was close
sad.
with them. Yes,
And you actually met Karen Reed through John, correct?
correct.
Sounds
After
like David
meeting
Yannetti.
Karen, you spent a good amount of time with both Karen and John, correct?
Correct.
As of January 28th of 2022, you had known Karen for maybe about a year or so,
Sounds correct.
and you'd see them especially on Fridays, correct?
Correct.
That would be sort of the day that you get together with both of them often.
Yes.
And of course, your children spent a lot of time with John and Karen, right?
Correct.
You entrusted both Karen and John with your kids.
Yes.
Sometimes your kids would even go on vacation with Karen and John, right?
They did go to the Cape. Yes.
Sometimes you'd see Karen without John at your house or on a ball field.
Correct.
And your daughter in particular would sometimes spend time with just Karen without John, correct?
Correct.
Your daughter would sometimes go over to Karen's house in Mansfield when she lived there, correct?
Correct.
And obviously, when your daughter would go to Karen's house in Mansfield, Karen would be the one in charge of caring for her, correct?
Correct.
And you were fine with that because you liked and you trusted Karen, right?
Correct.
And in your view, Karen was very good with kids, right?
Correct.
But you also had the opportunity to see Karen and John together, right?
Yes.
You saw how they interacted with each other over that year period that you knew Karen?
Yes.
You saw how they got along?
Yes.
And you never observed any arguments or bickering, correct?
I mean, they argued and bickered.
You had previously testified that you wouldn't even call it arguing, you just call it banter, right?
Yes. I mean, he would, I mean, no, he would get upset or like over if she bought expensive things for the kids.
Right.
Yes.
Yes. We will get to that. That would be the one thing that John would complain about, Karen buying like very nice things for his niece and nephew, right?
Correct.
Or he'd complain if, Karen was taking his niece and other girls to get their nails done, like extravagances like that.
Correct.
And one specific memory you have is when Karen bought his niece a very expensive sweater, right?
Correct.
And you recall John telling you that he wished that she hadn't done that because he considered that to be spoiling the girl, correct?
Yes.
But it was very clear to you from your observations that Karen really, really liked John. I'm sorry, John really, really liked Karen, right?
Sustained.
He certainly never told you or even suggested he was thinking about or planning to break up with Karen, right?
No.
Okay, so with regard to that Friday night, January 28th, sir, the plan was for you and John to go to McCarthy's to have some drinks because there was a storm coming in, correct? And because of the celebration of the girls getting into Bishop Fen?
Well, yeah, we were going out. It wasn't a continuation of the celebration of the girls. We were going out to have a few beers as guys.
Okay. And when you were leaving the house, John asked you to move your car, right?
Correct.
Where was your car when John asked you to move it that night?
Actually, I backed up my car. We were leaving the driveway, and John asked me to stop so he could move his car.
I see. And he wanted you to move your car because of the storm coming in, and he wanted Karen to be able to pull her car into the garage, right?
Correct.
And that was really thoughtful of him, wasn't it?
Yes, extremely.
And it showed you that he was being chivalrous toward Karen that night, right?
Yes.
He didn't want Karen to be out in the heavy snow later when she returned to his house during the expected blizzard, right?
Sustained.
Grounds.
You took from that there was an expectation that Karen would be coming back to his house, correct?
Objection.
Sustained.
You had no inkling that day that anything was wrong between Karen and John, correct?
No.
Everything seemed fine between the two of them, right?
Yes, he did mention though that night that he didn't understand why Karen had a plumber go to the house.
Because he had somebody that could have done that work instead of paying for the plumber, right?
Well, yes, yes.
Okay.
And
But in any case, the plan was for Karen to meet up with the two of you, right?
yes,
And she did show up to McCarthy's at about 8:30 PM or so?
yes, I guess, if
And-
that's the time.
And you saw an
I'm
affectionate,
sorry, what was the answer that you
If
said?
that was the time, I'm not sure about the timeline.
okay. It was sometime after you'd
Yes.
gotten there. Right.
Correct.
But you do remember when Karen arrived, there was an affectionate greeting between John and Karen, right?
Yes,
You saw them kiss, right?
yes,
You saw John put his arm around Karen,
correct,
and you saw that Karen sort of nestled into his embrace.
correct.
And when she did that, that's when he kissed her, correct?
Yes,
And they seemed happy to see each other, did they not?
they did.
That night they were affectionate,
Yes,
laughing,
yes,
happy,
yes,
like a normal couple.
yes.
No arguments.
No,
You witnessed no bickering, no tension, correct?
no.
And during the month before John's passing, that January of 2022,
I hope I don't have
you
to
observed their relationship in your presence.
explain why this is good
To be
testimony for the
normal.
defense.
Caring and affectionate, right?
Yes.
Thank you very much, sir.
That's a nice way to end that cross, actually.
Yeah.
Because they tried to make something out of like obviously very
You
minor
were asked a
argument.
number of
He
questions
described
about
it as bantering,
the
like
relationship between John and
it's
Karen
not even
that
negative.
night. Do you know what was going on behind closed doors other than what you saw?
Objection.
I'll allow it.
Oh, come
No.
on.
I'll allow it.
Do you know whether or not they texted each other that day?
No, that day, no.
Do you know whether or not there was any arguments that day?
I'll allow it.
Not to my, no, I don't know if they were, I don't know if they were arguing over the plumber situation. I
Do you
don't
know
know.
if there's any vulgarities that day?
No,
Do you know if there's any vulgarities that night?
no, not to my knowledge.
Do you know whether or not John
Wait.
was trying to end the relationship with Miss Reed?
Oh, between them, I guess. Yeah.
Do you know that, sir?
No,
Next question.
Do you know if there was any jealousy in that relationship?
I'll allow it.
I mean, Karen wouldn't let, they did everything together, a lot of things together. And I thought at times, yeah, you could see, she didn't want other women around John. I don't know, not at that, but
Thank you.
You follow up? All right, Mr. Cameron, you're all set, sir.
So I'll just get them down.
I'll see counsel at sidebar for just a minute, please.
I love that.
Counsel at sidebar.
That last barrage on redirect is like, well, you don't know. Maybe she was jealous. Maybe they were fighting. Maybe they were trying to end the, he's asking all these questions that this guy could possibly know, but can't really say how unless he uses hearsay statements from the deceased that he could just make up. But, people talk about lying on the stand. For some people, they can lie anywhere, whatever. But for people who are genuinely present, like this guy, it looks like his friend died. There's not much more to it. Like he seems nervous. He seems like he's still, when he thinks back, he gets sad that his buddy's dead and the circumstances around it probably. So he's just up there like that. That's a guy who doesn't seem like he wants to lie. Now, maybe he's a really good actor and he's up there, but lying in something like that, when you actually like it personally affects you and you take it serious and you're not in on the conspiracy, is something that's really difficult to ask people to do consciously. Sometimes it all depends on who you're dealing with. But that guy seems like a normal guy who goes to work, and has a family and just misses his pal. Was he even at the party?
At the house party? No.
Yeah.
He was only at McCarthy's. He wasn't even at Waterfall.
Right. So this is like, you know, John's going out partying with work, or partying, having a night of drinking with work buddies. This guy's outside of that group, you know, sees him earlier in the night. That's cool. But then, you know, they go their separate ways. It doesn't seem like he'd be in on anything. And he didn't seem to have anything bad to say about Karen Reed, actually. Like, I'm not.
He wanted to. Just that's the vibe. Well, the plumber, you know, he was unhappy about the plumber, and they bickered. They did bicker because Karen was buying the kids all this too expensive gifts. It's like he tried to make it sound bad. Well, they would argue, they would bicker, and then when it was exposed, because she was so nice, they argued because she was so nice to kids who were not her own.
It's just it's tough because, again, that guy, if he thinks she killed his buddy, like then yeah, he's probably mad at her now, you know, like it's a tough position to be in. Doesn't mean I just always want to caution people. It doesn't mean everybody's in on the thing, the conspiracy. And there are logical reasons for people to have some of these emotions that they could be miming or could be real, stuff like that. So always be discerning, and the jury's going to be trying to figure that out too. Like, you know, do I trust this person? Our son INV, welcome to Super Lawyer, and Here Comes Drama. Welcome to Lawyer. Thank you for joining the YouTube channel. By the way, guys, try out Super Tips on the show if you haven't played around with them. Supertip.gg/RL. It's a way to super chat, but you can attach an AI voice to it and make it say dumb stuff, and it's kind of just a fun way to participate. More importantly, they don't take the same giant cut that YouTube does out of those, so they're a great way to support the show if you want to. Big Boss, rate the attorney's courtroom drip and attire. We haven't really seen much of the attorneys today. They haven't had the camera on them too much. At least Court TV hasn't. Someone said Law and Crime has a camera on Karen Reed the whole time.
Oh, yeah.
Actually, technically, they said in Karen Reed, but I'm going to take that as a typo.
All right, we got audio.
Please.
I'm going to recall Nick Garino.
Okay.
This is the Mass State Trooper who did the Cellular Bright extractions on the phones. He testified yesterday briefly, subject to recall.
Rate their courtroom attire. Very basic Men's Warehouse. Straightforward, neutral colors. They look good. Suits are tailored and fit them. There's some attorneys out there that suits don't fit. And I don't mean that they don't fit well. I mean that they run out of material every time they try to make a jacket. It's a problem in the profession. Got to wonder if anyone will open a jacket and have a little white powder stain somewhere around the breast area.
Okay.
As they pulled the all-nighter last night, getting ready for trial.
Follow me, please.
The non-expert. I don't want to exaggerate my expertise in all this. I just press the buttons.
Or stand, however you're most comfortable today. Just do whatever you need to do, okay?
Thank you, Your Honor.
He must have some kind of injury. Hopefully not a grinder
Sir,
injury.
yesterday we talked about downloading phones and making what you called extractions.
Yes.
And from that data, you could create different types of reports.
So have Detective Garino say his name again, please.
I'm sorry. Again, for the record, could you introduce yourself to the jury and spell your last name?
I think it's this
for the
question
record?
wrong.
Yeah. Good morning. My name is Nicholas Garino, Guarino.
Thank you.
Sir, you mentioned yesterday that you downloaded a number of phones, or you were involved in the process of downloading a number of phones.
That's correct.
You explained to us that after you have the data analyzed, you can pinpoint certain items that you may want to put in a document.
Yes. So the extractions into a program of our choosing, Cellbrite is the most commonly used, and then we can take call logs or text messages, any information that the investigator is looking for.
When you downloaded Mr. O'Keefe's phone and you downloaded the defendant's phone, did you try to create, or did you create a report through Cellbrite, the software, that would show you all of Mr. O'Keefe's call logs?
Yes, I did.
And when I use the term call logs, what does that mean?
The call logs are the calls that the phone receives.
How do you create a report from Cellbrite? Can you just walk us through that process briefly?
Yep. So in the program, you can go in and select the calls from it and export it into different formats, PDF, XML, HTML, or you can create a portable case and extract them all as a portable case that we would see on my computer.
May I approach, Your Honor?
Yes.
Showing you a document of Mr. O'Keefe's call logs. Do you recognize that?
Yes.
And what is it?
It is the call logs. Just want to make sure it's between John O'Keefe and the defendant from, just want to see the dates, the 28th, January 28th, 2022 to January 29th, 2022.
Would this contain all the phone calls from his phone data for the calls between those two parties that night?
Yes, that's what I created.
I'd like to move this as an exhibit, please.
Okay. So,
If I could, Your Honor, just want to compare to make sure we have the same.
Okay.
Thank you, Mr. Brown.
That was it?
Thank you, Mr. Brown.
Okay.
Thank you, Your Honor. Consent.
Oh, you just wanted to look at it. Yep. Okay.
No objection.
Admit as an exhibit. And then they'll probably publish.
You captured all of the phone calls between two parties on that last document. Can you also do that with chats?
Yes, that is true.
And did you do that in this case?
Yes, I did.
You mean with texts?
I think they mean chat messages like Facebook Messenger.
Oh, okay.
Technically.
Fair enough. WhatsApp?
Yeah, they said there was a
Did
group,
you create a document
or
of
imply there's a group
chats
message. So who knows where it's
between
from.
the phones of the defendant and Mr. O'Keefe for after midnight for the evening hours of January 29, 2002?
Yes, I did.
May I approach?
yes.
2002. 2022.
This is a really old set of phones. They're driving those T9
Recognize that?
texting. My Nokia phone inspired by the Matrix.
Yes, I do.
And can you tell us what that is?
These are the texts from the defendant to John O'Keefe. Yes.
For January 29, 2022?
Yes, that's correct. So I'm sorry.
Thank you. I move this as an exhibit, Your Honor.
No objection, Your Honor.
Thank you.
Exhibit 24.
Let's see.
Did you identify or specify chat messages between John O'Keefe and a person named Jen McCabe?
Yes, I did.
Did you create a Cellbrite report?
Yes, I did.
May I approach?
Yes.
Celebrite sounds like vitamins you start taking when you're 71.
It's got electrolytes.
Celebrite. Because that stupid Celebrex commercial that I hear when I go over to my in-laws' house or whatever when they're watching HGTV. So apparently this cop was covering a different case, Sandra Birchmore case, and missed 32,000 messages
Yes, go ahead.
in his recovery. That has no bearing here necessarily, unless you're going to just impeach his competence.
Interesting.
Don't lie to me.
Handing you a document, do you recognize it?
Yes, this is the text messages between John O'Keefe and Jen McCabe on 29th on January 29th, 2022.
And this is to a search and cell right, you match their data, all of their conversations.
Yes, that's correct. Yes.
Okay. I move to introduce this, please, Your Honor.
No objection, Your Honor.
25.
Contemporary Compendium says, my memory is
Similarly
good then
to
as
the
it is
chat,
today.
Did you do the same
Also
with-
can't remember.
calls between Mr. O'Keefe and Ms. McCabe?
Yes, I did.
May I approach, Your Honor?
Yes.
Ninja Work says, Celebrite sucks to use and it's easy to fuck up. I work on it too.
Showing you a document, sir. Do you recognize that document?
Yes, this is the call log between John O'Keefe and Jen McCabe for, just want to make sure I get all the dates correct, just for January 29th, 2022.
I think this is good evidence, Your Honor.
Okay.
No objection, Your Honor.
Exhibit 26.
That a defense attorney, Robert Alessi, he's the local counsel there. He's so loud. He's so funny.
Mr.
objection, Your
Branca.
Honor.
Did you
He's
do
got
a
like
file
a
extraction
squeaky voice.
and a report on all chats between the phones of John O'Keefe and the defendant for a period of time?
Yes, I did.
May I approach, Your Honor?
Yes.
It's like he ran out of money before finishing puberty.
Giving you a document. Do you recognize that document?
Yes, this is the text messages between John O'Keefe and the defendant from January 28th to January 29th, 2022.
Someone called the witness scuffed Paul
Do I
Ryan.
move this into evidence?
Okay. Mr. Alessi?
No objection, Your Honor.
They're using chats and text messages interchangeably here.
Exhibit 27.
The boomers.
We need a voir dire, an MMS versus SMS expert. Versus whatever protocol Apple uses now, though.
Did you have an opportunity
Or
to
something.
make a report from some of the data from the defendant's phone from January 29, 2022?
What are you referring? I did make some reports from the defendant's phone.
What's a call log report?
Again, the call log report is the calls that the party makes to another phone. So it's going to show everyone they've called or attempted to call.
May I approach, Your Honor?
Yes.
Yeah, RCS. Thank you, Nico Ace. That's why you can smiley face text messages when both
I'm going to ask you to take a look.
both
at this
users have
document. Do you
RCS
recognize it?
Yes,
messaging.
And could you tell the jury what it is?
it's the call log from the defendant's phone for January 29th, 2022. It looks like everyone she called.
Introduce this as an
Sure.
exhibit, please.
No
God.
objection, Your Honor.
Thank you.
See a lung flying across the courtroom.
You think that's a Lessie? That sounded like one of those slightly autistic full volume coughs.
Introduced into evidence is the entire
Doesn't
call log of
cover his
calls to
mouth.
anybody and everybody to and from for that period of time.
Yes,
That's fair to say?
yes, that's correct.
And then can you further isolate calls between just two parties?
Yes, you can. You can search by phone number or name.
And did you do that with the defendant's records for some parties?
Yes, I did.
Did you isolate phone calls between the defendant and Ms. McCabe for the evening of January 29, 2022?
Yes, I did.
May I approach?
Yes.
Guys, take a look at this document. Do you recognize it?
Yes, I do.
What is it?
It's the phone calls from the defendant and Jennifer McCabe, January 29, 2022.
Thank you. Your Honor, I'd like to move this into evidence, please.
No objection, Your Honor.
All right, thank you.
29.
Stacy says Alessi isn't local. It's Yannetti who's local.
Oh, sorry about that. My mistake. Note to self.
Did you isolate calls between the defendant and Ms. Roberts for the night of January 29, 22?
Yes, I did.
Can I see the last exhibit, please? Thank you, sir.
Bev sounds more exhausted than an entire Porgy and Bess ensemble.
Guys, take a look at that document. Do you recognize it?
Yes, I do.
And that is correct. Giannetti is the local
It's
counsel.
the call logs between the defendant and Carrie Roberts for January 29th, 2022. Yes,
That's a report you created.
yes, it is.
Your Honor, I move this into evidence, please.
No objection, Your Honor.
Okay, thank you.
Exhibit 30.
Did you have an opportunity to isolate and produce a report for all chats between the defendant and Ms. Roberts for the night of January 29, 2022?
Yes, I did.
May I approach, Your Honor?
Yes.
So I'm handing you a document. Do you recognize that?
Yes.
And could
Better
you share with the
recognize.
jury what that is?
This is text messages between the defendant and Carrie Roberts on January 29th, 2022.
These are
I would move this into evidence, please.
No objection, Your Honor.
Okay.
not this is.
Jurors, this is the way we have to put evidence in cases in Massachusetts, okay?
Exhibit 31.
I guess somebody's falling asleep.
I mean, what? They are assuming that, like they.
So do
They
you
may
have
not-
an opportunity to
Oh, thanks, Judge.
identify a text message or a chat
Thought we were making
between
popcorn.
the defendant and a person by the name of Ingrid on the morning of January 29th, 2022?
Yes, I did.
May I approach?
Yes.
It's not just the state of Massachusetts; it's like all of them. You have to lay foundation, authenticate documents or video or anything that goes beyond statements, and then once the person authenticates that it's an accurate representation of whatever they're looking at,
Document, do you recognize
then
it?
they can publish. Barring
Yes.
objection.
Tell the jury what that is.
Yes, this is a text conversation between the defendant and looks like a group chat between Ingrid Curtis and Bill Curtis.
Did you make that report?
Yes, this is on January 29, 2022.
Thank you. I move this into evidence, please.
No objection, Your Honor.
Thank you.
Exhibit 32.
Someone said Alessi is not a criminal defense attorney, but they expect him to handle all
If this is a
expert
good time, if
witnesses.
Your Honor would permit.
Okay. Jurors, what we're going to do is we will take our morning recess now, and we'll take 20 minutes to a half an hour. We'll see you then.
Half an hour. So they're going to take a recess. You think we're going to get anything from the court? She didn't dismiss the witness, did she?
Yeah, I'm not sure.
I think they're
going
gonna
on,
have
but
some-
I've still got it here on the side. I'll
Yeah,
keep
yeah.
an eye on it.
So how's this morning going, ma'am?
So far, so good. My second show today already.
You're on those power hours.
Yeah.
You got a drive, an ambition, a goal.
Hey, I got a chat from Megan Fox. Hey, Megan, how you doing? $5. Great coverage, Branca. Hey, chat, go sign up for Branca's self-defense law class, which happens to be happening this Saturday, April 26th. In a single day, you can learn how to get hard to convict if you're ever compelled to defend yourself, your family, your property. Taught live by me, streamed to you at your computer. If you can't make it on Saturday, I would register anyway, because we make the recording of the class available to all the students for 2 weeks afterwards, so you can watch it at your leisure. We talk about everything you need to know to be able to win not just the physical fight, but the legal fight that follows, and we teach it all in plain English in a single day. Check it out at Law of Self. Oh, good heavens.
Oh, no.
lawofselfdefense.com. I'm the guy in the courtroom. Wow.
/advanced lawofselfdefense.com /advanced.
There it is.
Hard to convict. Defend yourself in life and then defend yourself in living. Make yourself hard to convict. Protect your family and then protect your rights.
Thank you, Nick. And thank you, Megan, for the prompt. That was very kind.
Let's see. We got this one. We got this here.
This witness had a hot mic moment last trial where he said, "Kill me," under his breath.
I have no idea, but apparently, yeah. So he's up there saying, "Kill me." I mean, sometimes like, you don't want to be testifying in a trial in general, unless you're an expert witness and that's your business. Like not a forensics expert hired by the state, but employed by the state. But I mean, there's some people out there who make their bones offering expert testimony. Wait a minute. I know one of them, but expert witness testimony is of varying value depending on specialization and scarcity, right? Like, there are certain people with extremely niche expertise, but when it comes up, no one else can do it, and they're worth a fortune. And then, of course, there's generally rather profitable ones like genetics experts, stuff that's going to come up all the time, and your credential list is basically like each year under your belt is just a little tick up on the hourly rate and what you can ask for. But it can be very lucrative, but most people who would want to be an expert witness all the time don't have the credentials to really do it effectively.
Yeah, it's a fantasy for most people. They imagine they have this highly demanded expertise in a courtroom. It's it usually doesn't work out to be a very profitable enterprise. I really like the expert witness testimony stuff when I'm doing it. When I'm in the stand and testifying, it's a lot of fun for me. But there's a lot of hurry up and wait in courtroom proceedings, and that part is I just find tiresome.
Well, the cool thing about an expert testimony is if you have the expertise, you probably care about the subject, are interested in it. It's what motivates your learning and excites your almonds, right? Like that's what you want to. You've spent a career talking about the law of self-defense. So getting up and talking about the law of self-defense is natural. You're getting paid. You get to delve into and refine your craft and maybe learn something new. Maybe teach the world something new through the courts. Like it's such an awesome opportunity to do stuff like that.
It's great. Generally, the response I get so first you have to go through voir dire as an expert. So you're questioned in front of the judge without the jury present, so you can qualify as an expert. And invariably, the reaction I get is I get voir dired by the defense. Generally, I'm a defense expert. And then the prosecution stands up and says, well, Your Honor, he's obviously an expert.
That's how you want it to go.
Yeah.
But one of the cool things that just reminded me, just a little exposition about the legal profession in general. Lawyers who are in the courtroom, and you don't even have to be at the highest levels. Lawyers in the courtroom are at critical junctures in people's lives, usually some of the worst times in their lives. You don't want to be involved in the criminal justice system or even the civil system. It's expensive, it's onerous, it's horrible, it takes forever. But the lawyers there all have an opportunity to literally change how law is understood and works with with any case. There's always a potential to do it. And there's something really exciting about that. Being able to mold the world around you, refine what we understand about a subject based on your input, your argument, your synthesis of it with some new piece of information. And that's a really intoxicating part of the profession. Well, the other intoxicating part of the profession is the substance abuse problems, but the first part's the more important one. And it allows people to change the world permanently. I mean, if you take a decision into the appellate courts and you sculpt common law out of whatever topic sometimes you sculpt common law. If you get a precedential opinion on a novel matter of law or change some old thing with a new argument, you've changed the world and you've changed our view of how our rights work. And that is a critically cool part of the profession. There's not many other cool parts of it. Most of it's just sweat.
Yeah, I really when I'm testifying as an expert, I'm not allowed to testify this is self-defense. I can't come to some final factual conclusion. And I tell the jury that's not my job. That's their job. Their job is to determine what they believe happened here. I can't provide them with the answer. What I can do is provide them with the correct questions. This is how it works. This is the legal algorithm. This is how you arrive at an answer. But of course, if you let me craft the questions, it kind of determines what the answer is likely to be based on the evidence.
Someone said Nick could be an expert witness about being an ex-drug user. That's not quite a joke. If you think about this though, if you have to bring in someone to testify as an expert about using certain drugs in certain ways, who would you prefer to have it to do it? Someone who's done it and also knows the legal system, or just some random guy? But no, I wouldn't claim to be. I think it's a funny joke, but how you gain expertise? So Andrew mentioned voir dire. I mean, lots of people seem to have obvious expertise, but they're not the only experts around. If you go watch My Cousin Vinny, you can voir dire someone who does not seem to be an expert mechanic at first glance and based on prejudices. And if you don't know that chick, you don't know that she knows everything about everything going on under the hood of a car. But they bring her up, Mr. Gambini brings her up on the stand, asks her questions, and clearly, the prosecutor in that case is able to ask her questions about her knowledge about being a mechanic, and she's able to deliver answers sufficient to qualify her as an expert.
That's a bullshit question.
Never.
They didn't make the Chevy with a posi traction in 1959.
Because it's impossible. No one can answer that question. Marissa Tomei. But never ever devalue practical experience just because some dork in a college or a lab says they know what happens. I mean, I would trust a heroin user to tell me about how to use heroin over a lab tech who has put heroin in mice. But only if you're talking about how to use it, right? Like that's anyway, sorry, go ahead.
Yeah, I observed this guy just said what you were noting earlier, $20 super chat. This guy extracted data from Matthew Farwell's phone and Sandra Birchmore, found 0 texts. Later, expert discovered 33,000 texts. I observed a trial one time. I wasn't involved, but it was a civil case that involved a car crash. And one of the issues was speeding. And they had a couple guys who had observed the car approaching the accident site. And they wanted to be offered as, the lawyer wanted to offer them as experts as to the vehicle's speed. And of course, they were challenged on this. And on voir dire, it turns out that these guys, their hobby was they would go to the local drag strip and bet each other on the speed of the cars as they came down the drag strip to within the nearest mile. And they put money on the line with each other. And the judge said, sounds like an expert to me, and let him testify.
If they do that all the time, though, you get a feel for how fast something's going. Like if you see something hundreds to thousands of times, you get really good. Like your brain gets really good at that pattern recognition, identifying it. It takes about this long to get there. They're probably going about this fast. Sometimes
that's how cops used to do it before radar. Mm-hmm. They would go to a racetrack and observe cars at different speeds and train themselves to see what a car looks like when it's doing 30, 40, 50, 60, 80, 1,000 miles an hour.
I wonder if cops do it now when they don't have their radar on or in the right direction or whatever. Someone can just look like they're going fast.
It's so easy now. They just drive around in their cruisers with the radar on continuously. There's no more. They have to stand on a bridge and get the little pistol thing out and point to the cars and press the trigger. Although they do that with the laser ones now. But the last couple times I've been pulled over, it was just, I just went by the car and he just pulled me over. It was always running.
Do they set up on bridge, like overpasses here where like you could barely see the top of the cruiser sticking over the, the cement barrier of the overpass, and they're over the back of their the car, and they've got the laser, and there's like a hill, and so everybody coming over the hill is getting they're getting
Right.
laser hair removal right out the gate, and you're done. They hit you, and then it's right down the entrance ramp, and they come up right behind you, and you're like, well, shit. Scott Christie,
There's no mistake. It's literally a laser. They have like a little scope with crosshairs on it. They put it right on your front license plate or some other shiny part of your car or motorcycle. And that's it.
you always just gotta blame someone else for driving your car. That's what you gotta do. My recommendation as a lawyer is to always take whatever child is in your car, put them in the driver's seat, and then you tie yourself up and duct tape your mouth in the back. That's the way I'm getting out of the next ticket. Scott Christie Jones says, if I get a ticket, I'm in trouble. Scott Christie Jones says, everyone is a Karen apart from the actual woman called Karen, it seems. If Karen Reed whacked John, then the Yaira live action trailer was good quality. Oh, damn. They have not sold me the story that Karen Reed in any way caused, certainly not intentionally, the death of John. I'm not convinced unintentionally either. But we got a long trial to go.
Yeah, so the statute is intentionally killed or acted with extreme indifference to human life, knowing her actions could cause death. So I don't think they're going for intentional. I think they're going for extreme indifference.
Man, they're going to have to show me how the injuries on that man are consistent with a car hitting him. So she backed up again. So forgive me. My understanding of the injuries that have been testified to so far are hematoma and then the lacerations. I think they called them, right? They called them lacerations.
Yep.
Yeah, I mean, so lacerations from mid forearm approximately to upper bicep, lower deltoid. And I think if they haven't testified to it, they're going to testify to a back of the head injury, which they will say knocked him unconscious, leading to the hypothermic death. That's my understanding, but that full testimony I don't think has been elicited yet. But that being said, I have a hard time believing a car backs into someone sufficient to knock them unconscious, and the only place it hits is the front above the eye, causing hematoma that they then fall. But there's no damage to the body. Like, this is a car. I mean, this is a 3,700-pound Lexus.
I mean, I guess in theory, you could argue she could have caused the death with extreme indifference simply by racing the car at him, compelling him to try to dodge out of the way, slipping and falling and hitting his head. And then there wouldn't be any car impact at all. But the prosecution is arguing impact here.
Yeah, okay. So, and someone says she somehow got up to 27 miles per hour backwards. So assuming that they're going to say that. So you've got a 3,700 pound Lexus SUV. I'm guessing on that. But it's coming backwards at almost 30 miles an hour. You've got a person completely unprotected by anything other than their skin getting hit by this car, skin and clothing. I mean, that's a lot of force. That's not an impact that is always going to be fatal unless there's the other circumstance, the back of his head hitting. Makes sense if that actually happens. But where is the other injury? Where's the bruising on the ribs, breaking of ribs, fingers getting busted, a leg getting ligaments getting torn, or anything getting trapped under the car as it's back, as it hits him. I don't know what position his body's in. I still don't know how you just get hit right here. It's like, oh, well, he's got a hematoma right here on his head.
Yeah, I don't. So all the shards, all the scratches, the lacerations in his arm, I don't understand how you get that from the shattered lens, but you don't have any bruising on the arm.
Yeah.
And we know he was bruising for some time because he had that, the right side of his eye swelling was not there at the scene, but it was much worse later in the hospital. So there was still some biological function. It wasn't an instant death. Swelling requires you to be alive for that to happen. There's no bruising on the arm. That looks like a taillight bomb went off next to it. That doesn't make any sense to me.
Yeah, they put an IED in that taillight to get the glass to shatter outward and lacerate all of these places. I mean, the light fixture's this big, tell me the physics of this smashing into someone and then going at them. Sufficient that a piece of plastic, like, mind you, these pieces of plastic or polycarbonate have to come at sufficient velocity to make 1-inch gouges down through your skin into, like, all of them are obviously into blood. Like these are not like light cuts. They're deep cuts, not down to bone as far as I can tell, but these are not like surface level scratches and scuffs. These seem fairly deep. So I don't understand the physics of it. I'm not a physicist. I'm a literature and creative writing idiot who became a lawyer. So I don't know. Maybe someone can show me, but I'm trying to figure out how something this big blows outward inexplicably and cuts this arm in the pattern. I wonder if we could pull up that picture. John O'Keefe arm wounds. Here we go. I'm just. Yes. I want turn safe search off. Oh no, it's just porn. I'm just kidding. That's a joke. So here I've got a picture. There is some. Just to warn everybody, there's a little blood on this. So if that makes you queasy, Andrew, if you want to pull this up, almost there. We got this guy right here.
Whoops, that's not what I meant to do. That's what I meant to do. Yep.
So again, we've got an arm. They're all going in the same direction. So we're supposed to believe that this thing blew past, like, this is a cut across the arm. How does this make sense in their scenario?
I don't know how a tail light, which is what, 5 inches by 5 inches, 6 inches by 6 inches, leaves a injury field that's a 2 feet long.
Right. And well, as men measure it, it's actually 1.5 feet. But no, and again, this is a thing that is impacting allegedly this body. So how is it bursting out to come across and make these cuts? Maybe the horizontal cuts could be made that there's a jagged edge if the car swipes his arm. But if the car is swiping his arm, I'm not seeing what is knocking him unconscious. Because there is a jagged edge kind of on the side front. It's the wraparound taillight cover that is missing. And there seems to be part of it left that's jagged up on the front. So I guess maybe if the car's like coming across his arm, you could see that. But then I don't see the unconscious or the force sufficient to knock him down, knock him out. It doesn't make sense. What it looks like to me is, I don't remember the type of dog that they have, but they have a very large dog, or had a very large dog that was rehomed very quickly after this, with a history of biting, from what I understand. Man, if they could introduce a dog bite case evidence file from that dog, consistent wound pattern, that would seal it. Actually, maybe not. But yeah, that's some, I don't know. I'm not seeing a coherent theory of the prosecution's case yet, other than, and I don't want to undersell this. I think people are going to be very tempted, especially YouTubers who watched the first trial. And there's this sort of public idea about Karen Reed's non-guilt. And I'm in that camp of Karen Reed's non-guilt, but I think there's going to be a temptation to overlook just how fucking damaging it is to have statement after statement after statement that can be interpreted as, I did it. I hit him. 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 They hit that. That's their first witness. I hit him. I hit him. I hit him. Now the defense did a good job dismantling it. But at the end of the day, they're going to get up on cross or on at closing argument, and they're probably going to say, I hit him. I hit him. I hit him. And that's going to be the opening statement. And then very shortly after that, when they start talking about Karen Reed's admissions and a media tour, she's trying to rehabilitate her image because of her consciousness of guilt. And they've got that coming in because she knows her own guilt. She's trying to rehabilitate her image. She's out making statements, and they're going to hammer those statements home. You will have juries look at evidence that does not make sense and go, but they said they did it though, and convict. That's a huge danger for Karen Reed, in my opinion. And that seems to be the state's only avenue that they're pushing right now. But
hey, man, I got to step away for a second. So I'm going to pull the court
No
back
problem.
up in case they come back when I'm away. I shouldn't be very long, but just in case.
Sounds great, man.
And I'll leave things in your hands.
My very capable and supple hands. But hey, if you guys disagree with that, of course, feel free to let me know. Drop it in the chat over on YouTube, at Rumble. You can join my locals and chat there with a little bit more select group, a little bit different feel. Sometimes depends on the day. Let's we don't have law conversations on this channel from what I hear, but you guys can always start one in the chat. Tell me what you think. What am I missing? What has the prosecution done? Not what do you think they're going to do based on the last trial. The last trial happened. Both sides have taken notes. Both sides have tried to figure out where they were unable to convince those last jurors to come their way. And now they've refined their arguments, and they're going to come at it again. They're going to have a different approach to the storytelling a little bit. They're trying to refine facts and nail them down. We'll say refine facts and give the Commonwealth a little bit of benefit of the doubt there on their profession. But we've got them shoring up that she said, I hit him, I hit him, I hit him. That's 3 times versus 2. We talked about both days, I think, the importance of the number 3 in the human mind when we're talking about language. Repetition is a critical thing. It tells people something. The reality is it doesn't tell you shit. It doesn't tell you anything at all, because there are any number of reasons why someone would say something 3 times. But the prosecution doesn't care what those reasons are. They just know that if it's said 3 times, for whatever reason, it will stick in the minds of the jury. And that's important. Let's see. We've got Tina Lewis. Did they recover any fabric matching John's clothing on or around the taillight of the vehicle? Not to my knowledge, but my knowledge is very limited on the evidence. And again, what they recovered only matters if it gets introduced. Or small pieces of the taillight tangled in the fabric. Again, not to my knowledge. To my knowledge, there were no pieces of the taillight recovered the night, or the morning of finding the body. Pieces of fabric or pieces of the taillight were found a day or 2 later, if I'm not mistaken. Interestingly, they were found by the body, not where the alleged collision would have taken place. A very strange sort of circumstance. Almost like, it kind of feels like someone stuffed a bunch of those taillight shards in a Doritos bag and walked to the scene and kind of sprinkled them out like rose petals at a wedding. But we don't know. We don't know. Critical part of the trial is what gets introduced as evidence. A family member of mine. I was talking to them yesterday after the trial coverage, and they had asked me about like what the purpose of having something stricken from the record is. It reminds me that some people may not understand that closing argument has to be drawn off of facts that are in the record. You cannot make up or manufacture a fact, and you cannot bring in a fact that is not included. Have to pull all of your factual basis for your arguments from the record. In theory, obviously there's a practicality of people missing stuff, or maybe the other side doesn't care, et cetera, et cetera. But to have a legitimate legal basis to make a factual assertion that close, you have to have the facts in the record. One of the most interesting things that the Kyle Rittenhouse case was, they lacked the factual basis for his walking around the illegal carrying of the firearm claim, because they failed to establish, I believe, that he was carrying that firearm. Like, they just didn't get that fact in the record. It was just weird because everybody just assumed he was carrying that firearm. It was like known. It is known, Game of Thrones style. I believe that was the missing fact, but it was something akin to that. If it wasn't, it was really close. It's this idea that you missed the most obvious thing. And someone asked yesterday, why did they point to the defendant in the courtroom? Has anybody ever been, I think this is in my locals chat, but has anybody ever been let off because they didn't identify the defendant? Yes, tons of cases. If no one says, yeah, that's actually Karen Reed right there. They go through this whole trial and they say, no one says that's Karen Reed. They go, Your Honor, who? We move to dismiss. Like, no one correctly no one identifies her. No one says this is the person I saw. No one can link her to this thing. Maybe she walks. You have to establish all these facts, and those are brought into closing arguments. So something that needs to be considered as to why some of these facts, or why it's so critical to limit your analysis to facts that make it in the record. This is a tough thing for defense teams to deal with from sort of the psychological aspect of building their case. They know a ton of facts that won't come in. They know prosecutors may have statements. Prosecutors may have video that shows the person committing the crime. And for whatever reason, the video is not admissible. It's been tainted in some way. They know it's accurate. They know it's right. They've watched the person murder someone on camera, and they just can't get that in there. You can try all day for everything else, but if they can't get that video in, their case could crumble just based on that. So that's why it's critical to do this, and why I try to. People ask, well, like, why I didn't research the first case and stuff like that. One, it would take forever. And I don't have time to go back and rewatch 6-week trial leading up to this one. But two, the jury isn't going to know any of that stuff. And what's going to come into the record in this case is what matters in this case. What came into the record in the last case only matters for purposes of impeachment. The last case did not happen in this courtroom for those jurors. Until someone says, hey, we remember at this date in this courtroom, you were asked this question. And then that's the only part of the trial that matters in that moment. You can know everything from the first case. You can know first witness. They can change their entire witness list. They can change who they're going to, what questions they ask them. They can ignore their entire testimony from the first case if they thought it was bad. So focus on what's happening in this case when you're kind of trying to make your analysis of it and make sense of what's going on. Welcome back.
Yeah. Made it. Just had to put some pants on.
Coward. Not Cupcake says, good morning, ladies. Do you two sweeties think Carrie Roberts was testifying to the taillight possibly catching people's coats to lead Brennan to being able to say the taillight housing made those cuts to John's arms? I mean, if nothing else, it's going to draw a parallel in the jury's mind when a medical expert comes in and makes testimony that those cuts are consistent with a jagged taillight hitting an arm, which you have to assume the state is going to have someone say that this caused it. mean, it might be a ridiculous opinion, but they're going to have to do that. At least in my opinion. I don't know. We got some super tips here. We got...
In the previous case, they said she pushed the accelerator 75%, but wasn't as snowing out. If traction control kicks in, that would explain pushing the gas more.
Whoa. Look, it's still an AI voice. Who knows? Actually, that guy's just retarded. Yeah, I mean, traction control. Dude, I had a car that it had traction control, and when you turn from the local county highway onto my road, it immediately goes uphill. And I had a Ford Fusion that was a hybrid, and if there was fresh snow, it wasn't going to make it up that hill with traction control on. Like, it'll just stop the wheels from spinning. And the car cannot get enough. It just can't get going. There's nothing happening. So eventually, yeah. I mean, I don't know though. We're gonna have to find out. What she puts the pedal down 75% of the way, apparently, and how fast the car gets going is going to be a marrying of black box data and Waze data, and they're going to try and sell us their narrative. And then the defense is going to come say that's bullshit. Like that couldn't have possibly gone that way. What do we got here? Pig Newton, welcome to Paralegal Status. Caspian Paddock says, have a shekel, sad queer. Don't spend it on liquor. Thanks. I can't, but that's fine. I don't really want to buy liquor.
An expert can command the room. Let us never forget Dr. Muffins.
Ah, yes. Who could forget Dr. Muffins from the Johnny Depp trial? What do we got here?
Subscribe, subscribe while we're waiting for court, folks. I'd love to break 198 today. First, I have to get to 197.5, and court is back.
Based on eating those chips, you may need some jumping jacks.
Could I see counsel for a minute regarding scheduling, please?
I'm just kidding.
And there goes the volume. No, I'm eating. It doesn't matter.
I was just kidding. You're not fat anyway.
Oh, no, I'm fat. I need to lose some weight for sure.
Oh, okay. You are fat. I'm going to shame you.
Yeah, sure. I got to lose 25 pounds.
Oh my God. You are in for a long haul, brother. But that's what's the problem, right? Is you haven't done a long haul in a long time. Instead, you're just loafing around like sad bread on a non-Italian shelf.
I'm on a 2-year cycle. I get down to like 190, and then I just spend the next 24 months going back up to 220, and then I got to come back to 190. And
come on, at that size, you're not on a 2-year cycle. You're on a 2-year tricycle. Okay, I need to know. Have you ever seen those? They give them to like adults who shouldn't drive but need to get around. Typically, they live in some sort of assisted thing, but they're able to go out and do stuff. And they're those like tricycles that look like Pee Wee Herman's, all grown up. And I feel like you could pedal right. And there's no amount of pedaling that can make them go over 2.5 miles an hour. I don't understand them. I'm like, how do you get anywhere? It looks like it's like a horror movie clown. Like it's always pedaling towards you. It'll never stop, but it'll never get there.
But for them, it's like a normal person getting their first car. It's like freedom.
Man, it's like, I just don't understand the physics of the bike. I'm like, how does it not go any quicker? Like it could go downhill, but it'd go backwards uphill if you tried. It's weird. Here, what do we got?
I'm glad Nick has not changed as a person. He changed his habits, but not himself. A true legend.
No, don't send nice ones. Thanks. What do we got here?
Oh, I have a great idea. I am going to become an expert on boxing with my 2 record. I can also be an expert on Molly and cocaine use. I used cocaine 3 times and ruined the party. No more goals ever on the Toe Morning Show. Starting next year, Nick and Patrick will be seething more than they already are. Another win for the Toe.
You know any boxers? in your life?
No.
Okay. What about
I guess Andrea Burkhart's a boxer, right?
Oh, that's cool. Oh yeah, she is. I would not want to fight her. She looks like she could throw down. Well,
that's why I carry a gun.
The internet goes wild as Andrew Branca admits he carries a gun because Andrea Burkhart. He's terrified. You know someone generally who's played sports before, though, right? Like if you asked them their win-loss record, like how would that sound? Like I'm not a sports guy, so I don't know. Like 15-1 or something like that, right? Have you ever heard of one just being 2?
2? 2 is...
What's your win-loss record? It's 2. I've never heard of that.
That's like my marriage win-loss record. 1 win, 1 loss. 1-on-1 is 2.
So 2 is 1-1. Okay, now the math adds up.
Nick pulling himself together inspired me to finally pull up my crusty pull-ups. My stanky diaper is covered in doo-doo and was stuck to my ankles for weeks.
Okay, that was horrible. I didn't want that. But thank you, though. Malcaron says, gotta know, Nick, who do you think fills out a circus tent better, Sean or Kraus?
All right, Mr. Brennan, whenever you will.
Both seem to be capable. They can't be in the same areas. It'd be 2 neutron stars collapsing in on themselves.
Good afternoon. Just a few more items I'd like you to recognize. Your Honor, may I approach?
Yes.
Man, that was 40 minutes.
Showing you an envelope. Do you know what's in that envelope?
Yes, the
No, it was an
raw
hour.
data extraction of John O'Keefe's cell phone.
All right, ask it to be marked simply for identification, please.
Okay. Thank you.
Second folder.
Yes, the raw data extraction of Jen McCabe's cell phone that I created.
Thank you, sir. Your Honor, ask it to be marked for identification as well.
All right.
Act.
Thank you.
Trooper, you shared with us that you downloaded the extraction of the phones that you identified and you made reports based on specific identified features. For example, a conversation between 2 people.
Yes, so I didn't do the extraction of Jen's phone, but I made those reports with the PDFs from the data extraction.
Relative to Mr. O'Keefe and the defendant's phones, you created a document that provided us the phone calls between them on January 29th.
Yes, that's correct.
And separately, you also provided a document that included all of the chats or text messages between John O'Keefe and the defendant on January 29th, 2022.
Yes, it also included the 28th.
Thank you.
Yes.
And in that compilation, did you put together or do you create or review a PowerPoint of those?
Yes, I did.
And what was the point of that?
Just to show the texts and calls in a chronological order, because that way you're not looking at 2 different documents, trying to compare and contrast the calls to text messages when each is coming in.
And did you begin that PowerPoint presentation with a call at 2:16:10 on January 28, 2022?
Yes, that's correct.
And are there additional chats or text messages earlier that morning?
Yes, there's a handful starting around 9:45 a.m.
May I
Yes.
approach, Your Honor?
Yes.
Handing you a folder, sir. Could you take a look at it? Let us know if you recognize what's in it.
Yes. So this is the bulk of this is the PowerPoint calls and text messages, and at the beginning there's the messages from before 2:16 in the morning.
I'd like to introduce this as an exhibit, Your Honor.
Okay.
No objection, Your Honor.
Great. Thank you.
Wait, was that Alessi? Or was that Yannetti on the
For
objection?
permission, I'd ask a witness to read the text
Sounded-
messages from the
sounded
morning
loud.
hours, and then we begin the PowerPoint presentation.
Okay.
Thank you, Your Honor.
Do you have a hard copy of those for me?
It was provided. I'll see if you have another copy if you don't have it.
All right. I have, it's in here, the
That was Alessi. So,
pre-
oh yeah,
20
Alessi.
hours,
Alessi's going to take care
the
of the
ones that
experts.
we discussed at
so.
sidebar. If you don't have them,
The
Cross
defense
is gonna be
has
a-
copy to you, Your Honor.
thank you.
Full volume.
Sorry.
Thank you, Ms. Little.
Okay, thank you.
May we begin, Your Honor?
Please.
Could you first read the text messages from that morning to the jury?
Yes. Apologize if I misspelled things or state things. Start time, all right.
Oh, this is going to be
It's a little different than
very
the format I had before.
boring.
All
or
right, this is from
tedious.
Karen Reed
Okay.
to John O'Keefe. You have really hurt me this time. This was sent at 9:49, 20 seconds a.m. on the 28th. From John O'Keefe to the defendant. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy. This is sent at 10:02, 56 a.m. on the 28th. From the defendant to John O'Keefe. I'm not the same as everyone else. Most of the time I try to do what is healthy/smart for them. More importantly, I try to support you in what you need. You just lashed out at me and said terrible things. I don't know how you've gotten to this point with me when I'm just trying my hardest. You made your point and continue to beat me down. I have a lot going on too. Physically, I am falling apart and trying to get answers and help. 10:09:49 a.m. on the 28th. From the defendant to John O'Keefe. I am just your girlfriend. I am not a perfect parent. I'm trying very hard and sometimes treat them - nothing like I used to. 10:46 a.m. on the 28th. From John O'Keefe to the defendant. I know, I'm sorry for lashing out. I'm just hurting and struggle daily with them. Always feel like I'm failing at this parenting thing. I wasn't built for this. 10:12 a.m. on the 28th. The defendant to John O'Keefe. Kaylee isn't perfect, but everything wonderful about her is because of you. 12:21:36 p.m. on the 28th.
The malice.
From John O'Keefe to the defendant, an emoji is sent.
Just the whole
At 12:21:59 on the 28th. From the defendant to John O'Keefe. It's true. I know she's her mother's daughter, but she wouldn't be so bright and successful if she lived with anyone else. 12:22:51 p.m. on the 28th. From the defendant to John O'Keefe. Wow, Kristen just sent 2 back-to-back messages to not lose your faith in the kids. 12:31:28 p.m. on the 28th. From the defendant to John O'Keefe, or in yourself. 12:31:41 p.m. on the 28th. From John O'Keefe to the defendant. There's 2 emojis sent at 12:32:06 p.m. on the 28th. From the defendant to John O'Keefe, no, and there's 2 emojis. Life can pick you up sometimes. Please be happy with them and put away your frustrations for the rest of the day. And be so proud of yourself, JJ. That's 12:33:35 p.m. on the 28th. From John O'Keefe to the defendant, that's what bothers me more than anything. Should have sent Peg's or Sarah's W-2s. We are all equal guardians. 1:18:21 p.m. on the 28th.
Oh, please be done.
From the defendant,
Damn
John
it.
O'Keefe, maybe you can call someone. 1:21:55 p.m. on the 28th. From John O'Keefe to the defendant, like who? 1:46:42 p.m. on the 28th. From John O'Keefe to the defendant, what time are you coming here? 1:47:38 p.m. on the 28th. From John O'Keefe to the defendant, it's another emoji sent. 2:05:30.
Is it a grapefruit? What is it?
On the 28th. From the defendant to John O'Keefe, I don't know what time. Feel kind of out of it. Just trying to clear my head. 2:06:07 p.m. on the 28th. From John O'Keefe to the defendant, he writes, okay. 2:06:25 p.m. on the 28th. From the defendant to John O'Keefe, text me when you guys settle in later. 2:06:44 p.m. on the 28th. From John O'Keefe to the defendant, sure. 2:06:58 p.m. on the 28th.
He basically has to read
the
every
defendant
message because
to-
the,
oh, no,
the
that's-
defense,
It's cut off, yes, sir.
the prosecution will
Yes.
want to just have the negative messages or whatever they perceive as negative. The defense will want to flesh out this is a relationship.
I believe it
of
Yeah,
people who
goes to
speak
the
back
next
and
one, so
forth.
start.
So it doesn't give a false impression.
Yeah, sorry.
It's that rule of completeness we were talking about.
With the court's permission, we'll begin the PowerPoint.
Yes.
Should I
At your
do it
leisure.
first? Okay. The phone calls, text messages, and then we'll start with the first slide. This is from the defendant to John O'Keefe. I feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said. 2:16, 10 p.m. on the 28th. From John O'Keefe to the defendant, not sure what you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it. 2:17, 16 p.m. on the 28th. From the defendant to John O'Keefe, things in my own life have been difficult too, 33 p.m. on the 28th.
I'm sure you've told him.
From John O'Keefe to the defendant, I know.
See?
2:17:40 p.m. on the 28th.
100% success rate on predicting texts.
At 2:17:45 p.m., the defendant calls John. The phone call is answered and they speak for 2 minutes, 22 seconds. 2:23:02 p.m., the defendant calls John. That's again answered. At 10, and they speak for 1 minute, 2 seconds. At 2:24:17 p.m., the defendant calls John and the call is rejected.
Just like his life.
From the defendant to John O'Keefe, tell me if you're interested in someone else. Can't think of any other reason you've been like this. 2:25:18 p.m. on the 28th.
Oh.
From John O'Keefe to the defendant,
Oh my.
nope. 2:25:33 p.m. on the 28th. From John O'Keefe to the defendant, things haven't been great between us for a while. Ever consider that? 2:26:03 p.m. on the 28th. At 2:28:40 p.m., the defendant calls John. That call is rejected.
Mr. Greeno, can you explain to us the difference between not answered and rejected?
Yes, so if the call is not answered, that means the call rang out and goes to voicemail. If the call is rejected, that is someone actively hitting the send to voicemail button to disable the call.
That would
to
be
stop
me.
it from ringing.
I reject calls all day and it has nothing to do with
From John
mood
O'Keefe to the defendant,
or feelings
kids are
towards
here,
the
not in
person
the mood to
calling.
talk. 2:29:03 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into it anymore. That's fine,
Conversation's
but I don't
infuriating.
want to keep trying and you keep treating me like this. 2:29:12 p.m. on the 28th.
No, I said my kids are here.
From the defendant to John
Can't talk
O'Keefe,
right now.
I'm trying to hug and kiss you this morning and you whack me in the face with a pillow. 2:29:59 p.m. on the 28th. From the defendant to John O'Keefe, last night you're basically like, yeah, what about when we talk about the future? So why don't you just admit you're not into so much anymore? 2:30:23 p.m. on the 28th. From John O'Keefe to the defendant, not how it went down, but okay. 2:30:26 p.m. on the 28th.
He just wanted to get some. That's all.
From the defendant to John O'Keefe, can you please admit your head is out of the game with us? 2:30:52 p.m. on the 28th.
This is
John
This
O'Keefe
is
to the
just a
defendant,
frustrating
sick of always
conversation
arguing and
between a
fighting.
couple.
It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently.
Oh, no.
2:32:28 p.m. on the 28th. At 2:32:47
If he can't jump, he can't
p.m.,
dodge.
The defendant calls John. That call is rejected. John O'Keefe to
Stop
the defendant,
calling me.
OMG, stop calling. 2:32:54 p.m. on the 28th. From the defendant to John O'Keefe, then why would you start with me this morning? 2:32:58 p.m. on the 28th.
Oh shit.
From the defendant to John O'Keefe, you're setting me up to fail. 2:33:05 p.m. on the 28th. From the defendant to John O'Keefe, you started a number of fights from your end. 2:33:26 p.m. on the 28th. And John O'Keefe to the defendant, I've explained it a few times already, not doing it again. 2:33:31 p.m. on the 28th. From the defendant to John O'Keefe, so you're not into this anymore. 2:33:41 p.m. on the 28th. From John O'Keefe to the defendant, not into fighting all the time, correct. 2:34:03 p.m. on the 28th.
She likes the drama, the
From the
crazy
defendant
ones
to
are
John
like that.
O'Keefe, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world. 2:34:11 p.m. on the 28th.
She's not happy unless there's drama.
From John O'Keefe to the defendant, he sends an emoji. 2:34:19 p.m. on the 28th.
She wanted their relationship to go
From the defendant
forward.
to John O'Keefe, and stop
It ended
starting
up
with
going
me.
backwards.
2:34:20 p.m. on the 28th. 2:34:29 p.m. The defendant calls John. He rejects the call.
Anyone in a long-term
John
relationship
O'Keefe
out
to
there
the defendant.
seeing
I'm
these
not
texts
answering.
and not
Stop
having
calling.
anxiety?
2:34:42 p.m. on the
Fucking
28th.
frustration.
From the defendant to John O'Keefe, can you please answer after how you treated me earlier? 2:34:43 p.m. on 28th. 2:34:54 p.m. The defendant calls John. That's rejected. John O'Keefe to the defendant. Kaylee is right here. 2:35:02 p.m. on the 28th.
This is not a huge
The
fight.
defendant to John O'Keefe. You start a rager with me out of nowhere and then tell me you're sick of fighting with me. 2:35:41 p.m. on the 28th. The defendant to John O'Keefe. I'm going to grab a drink in a bit. 2:38:14 p.m. on the 28th.
This is how some women ask for sex.
2:38:42 p.m. The defendant calls John. That call is rejected.
Reminder, John told her, like, I'm with my
The defendant
kids.
to John
I
O'Keefe.
can't talk
Can you
right
please
now.
answer?
Man just needs some
2:38:52
time.
p.m. on the 28th. From John O'Keefe to the defendant. No, Karen. Not sure why you need to announce that you're going. Not
Oh,
sure
that's
why you
a
need to
dick
announce
text.
that you're grabbing a drink, but have fun.
She was inviting you out, you asshole.
On the 28th. From the defendant to John O'Keefe, seeing if you want to meet me later.
You gotta speak woman,
22
John.
p.m. on the 28th.
If you would have.
From the defendant to John
be
O'Keefe,
alive.
can you please call me? 2:32 p.m. on the 28th. From John O'Keefe to the defendant, have to take them to the doctor. He has practice. 2:55 p.m. on the 28th. From the defendant to John O'Keefe, yeah, 5 minutes. 2:41:17 p.m. on the 28th. At 2:43:01 p.m., the defendant calls John. It's not unanswered. At 2:43:45 p.m., the defendant calls John. The call is rejected. John O'Keefe to the defendant. My father just walked in. 2:43:58 p.m. on the 28th. The defendant to John O'Keefe. Okay, can you please call me for 2 minutes?
He just
2:44:14
walked
p.m. on the
in.
28th. John O'Keefe to the defendant. Not right now. 2:44:23 p.m. on the 28th. The defendant to John O'Keefe. I'm there when anyone else needs me. 2:44:26 p.m. on the 28th. At 2:45:32 p.m., the defendant calls John. The call is rejected. The defendant calls Mr. O'Keefe. Yes, John, you gave me utter grief this morning. I'd like you to call me for a minute. 2:46:16 p.m. on the 28th. The defendant to John O'Keefe. I've been trying to get over the hump with is arguing, and now you tell me you're not into doing things, and you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail. 2:47:08 p.m. on the 28th.
Doesn't want to fight. But
Defendant to
he
John
did.
O'Keefe. I've been dealing with my own personal crisis over things I have zero control over. I'd like to lean on you too sometimes. Instead, I just hear everything I've done wrong. 2:48:34 p.m. on the 28th.
Missy Lania says every single couple
56
that's
p.m.
ever
the
have an
defendant calls
argument
John.
better
The
use
call's
signal
rejected.
and
At
wipe their messages.
2:51:13 p.m. the defendant calls John. It's rejected. 2:52:37 p.m. John calls the defendant. It's not answered. At 2:53:56 the defendant calls John. Again, not answered. The defendant, John O'Keefe, you seriously cannot pick up the phone for 2 seconds. 2:54:13 p.m.
Time demands keep going down for the phone call.
2:58:05 p.m. the defendant calls John. It's rejected. At 2:59:13 John calls the defendant. The call is answered and they speak for 4 minutes 59 seconds. From the defendant to John O'Keefe, why don't you meet me at Hillside at 4:30/5? 3:08:55 p.m. John O'Keefe to the defendant sends an emoji at 3:10:08 p.m. on the 28th. From the defendant to John O'Keefe, or whenever you get, or whenever you get everyone settled, 3:10:35 p.m. on the 28th. From John O'Keefe to the defendant, like I said, doctor now, and he has practice till 6. If you want to go start drinking, then go for it. 3:36:21 p.m. on the 28th. The defendant to John
A little
O'Keefe,
late.
I didn't know the times of his practice. 3:36:40 p.m. on the 28th.
There's a joke.
And the defendant to John O'Keefe, I just want to give you space at the house without me there. So rather meet you out than meet at the house. 3:37:01 p.m. on the 28th.
Guarantee she's addressing
John
the
O'Keefe,
wrong
the
issue with that
defendant.
text.
Yeah, well, now there's a 72-year-old taking up shop on my couch. 3:37:36 p.m. on the 28th. The defendant to John O'Keefe, yeah, that too. 3:37:46 p.m. on the 28th. From the defendant to John O'Keefe, is he going to Collins? 3:38:23 p.m. on the 28th. John O'Keefe to the defendant, not tonight. 3:38:32 p.m. on the 28th. From the defendant to John O'Keefe, so do you plan on going out tonight? 3:39:01 p.m. on the 28th. From John O'Keefe to the defendant, Karen, I don't know. 3:39:17 p.m. on the 28th. John O'Keefe to the defendant, you're like jonesing to drink, so go. 3:39:43 p.m. on the 28th. From the defendant to John O'Keefe, okay, well, after how this morning went down, I don't think I need to be back over there with you. Get frustrated at how I am with the kids. Has nothing to do with drinking. 3:40 p.m. on
I'm
the
with her on
28th.
that one. His kids are there. They're arguing over that. Just
From the
give them a
defendant to
pause.
John O'Keefe, I am paranoid now that everything I do with them is problematic. So rather see you for a minute without it, kids around. 3:40:24 p.m. on the 28th. From John O'Keefe to the defendant, what's your plan? At 4:47:16 p.m. on the 28th. From the defendant to John O'Keefe, don't have one. 4:50:09 p.m. on the 28th.
Except to pester you all day.
For John O'Keefe to the defendant, so still home. 4:50:26 p.m. on the 28th. The defendant to John O'Keefe, yes. 4:50
Hasn't gone out drinking yet.
4:45 p.m. on the 28th.
Like
From
2
John O'Keefe
hours.
to the defendant, we just got home, waiting to see what Papa decides here, or else I have to get Patrick at 6. 4:59:45 p.m. on the 28th.
Another thing to remember though is these are text
The defendant
messages.
John O'Keefe, okay. 5:01:55 p.m.
They
on
seem
the 28th.
way more laborious
John
when
O'Keefe
the
to the defendant,
timestamp
so are you staying home or
is
coming
read
here?
out, and so is the
5:02:23
message
p.m. on the 28th.
by a forensics cop.
From the defendant to John
This
O'Keefe,
is-
waiting to see what you end up doing. I don't want to hang out at the house too much, like I said. 5:03:40 p.m. on the 28th. From the defendant to John O'Keefe, I think it's clear me around the kids, excuse me, I think it's clear me around with the kids around is slowly killing our relationship.
Oh,
and
it's
our
also-
relationship is much more important to me.
So passive aggressive.
5:04:16 p.m.
Yep.
on the 28th.
Sounds like he
John
bitched at
O'Keefe
her
to
about the
defendant,
kids, and then
well,
she's
there's a
taking
blizzard
it
coming,
like
so we'll be inside all weekend.
probably beyond what he meant.
5:04:19 p.m. on the 28th. The defendant to John O'Keefe, it will be over by noon tomorrow. 5:04:44
She
p.m. on the
meant
28th.
his life.
John O'Keefe to the defendant, don't think so. 5:05:27 p.m. on the 28th.
They're fighting so hard they're disagreeing over the weather.
Defendant to John O'Keefe, I don't want to keep having this constant conflict of the dynamic of the four of us. The harder I try, the more it kills our relationship as a couple. It feels like utter shit to be in that position. Rather just meet you out for drinks when you figure out what your night looks like.
But it's not about the drinks.
5:06:45 p.m. on the 28th. John O'Keefe to the defendant, well, I have no idea what's going on, so do what you want.
I gotta step away
5:07:34
for a
p.m.
second.
on the 28th. John O'Keefe to the defendant, need to figure out what everyone here is doing. All I know now is Madeline is coming over. No clue about Patrick yet, or if Papa is planning on hanging it for a few more hours. 5:29 p.m. on the 28th. From the defendant to John O'Keefe, okay, well, when you know the story and if you want me to come up, let me know. 5:36 p.m. on the 28th. John O'Keefe to the defendant, no, Karen, you decide what you want to do. 5:18 p.m. on the 28th. From the defendant to John O'Keefe, I know your heart isn't in this anymore. I felt it for a while and especially lately.
Tell me you
I'm
love
willing
me.
to try more, but not if you approaching the point of indifference. If you want me to come up and you can head out for a while, then say so when you know what your father is doing. 5:23 p.m. on the 28th. John O'Keefe to the defendant, you come up and I head out, really?
I have to go deal with a
5:48.
quick issue for a family member. Be right back. As fast as I can.
John O'Keefe to the defendant, I've told you already, I don't bounce back as quickly as you do after we have a battle. 5:52 p.m. on the 28th. From the defendant to John O'Keefe, no, head out together with an emoji. 5:49 p.m. on the 28th. From the defendant to John O'Keefe, or meet out. 5:54 on the 28th. John O'Keefe to the defendant, gonna send Patrick to Collins tonight. They're picking him up around 7. Mike may hang out too when he brings Matt over. So why don't you just come over? 5:42 p.m. on the 28th. From the defendant to John O'Keefe, Mike doesn't want to go out for a bit. 5:20 p.m. on the 28th. From the defendant to John O'Keefe, I would like to, been a shit day from the jump. 5:33 p.m. on the 28th. From John O'Keefe to the defendant, probably 5:39 p.m. on the 28th. From John O'Keefe to the defendant, I just got sober an hour ago. 5:56 p.m. on the 28th. From the defendant to John O'Keefe, I'll text you, hang with Mike for a few. I don't need to butt in. Text me if/when you think you may head out. 5:12 p.m. on the 28th. From the defendant to John O'Keefe, can you send me Tim Zoll's contact info, please? 5:38 p.m. on the 28th. John O'Keefe to the defendant, I paid the last bill. 5:27:08 p.m. on the 28th. From the defendant to John O'Keefe, you didn't have to do that, thanks. 5:27:43 p.m. on the 28th. From the defendant to John O'Keefe, are you really not going to accept my friend request? 5:33 p.m. on the 28th. John O'Keefe to the defendant, an emoji on what, FB? 5:33:01 p.m. on the 28th. From the defendant to John O'Keefe, yeah, we've been going out for 2 years. 5:33:20 p.m. on the 28th. John O'Keefe to the defendant, I haven't gone on. You defriended me over a year ago, I believe. 5:33:48 p.m. on the 28th. From the defendant to John O'Keefe, Kerry texted that they're headed out in a bit. 6:05:29 p.m. on the 28th. From John O'Keefe to the defendant, okay. 6:14:55 p.m. on the 28th. From the defendant to John O'Keefe, she's going to let me know where. 6:17:51 p.m. on the 28th. From John O'Keefe to the defendant, so you're going to meet them. 6:18:12 p.m. on the 28th. From the defendant to John O'Keefe, just presenting it as an option. Wouldn't mind hanging out with them for a drink. 6:19 p.m. on the 28th. From the defendant to John O'Keefe, is Mike over? 6:27:26 p.m. on the 28th. From John O'Keefe to the defendant, yes. 6:29:45 p.m. on the 28th. From the defendant to John O'Keefe, sounds you're like good with getting together tonight. 6:31:32 p.m. on the 28th. From the defendant to John O'Keefe, was hoping after this morning you'd be interested in smoothing things over with me. 6:32:24 p.m. on the 28th.
Any good text yet? Any juicy
John
stuff?
O'Keefe to the defendant, told you to come over, but you insisted on meeting me out somewhere. 6:33:44 p.m. on the 28th. From the defendant to John O'Keefe, Mike is a little off with me for a while now. I've said that multiple times. 6:34:34.
She's just looking for attention.
From John O'Keefe to Karen, the defendant, time to get over it, Karen. He's fine. He was fine the other night when he came by. 6:38:09 p.m. on the 28th. From the defendant to John O'Keefe, yeah, wouldn't mind hanging out with other people, like another female too. 6:39:09 p.m. on the 28th.
Oh, that was from Karen. Okay.
From John O'Keefe to the defendant,
Oh,
where are
boy.
you meeting them? 6:39:28 p.m. on the 28th. From the defendant to John O'Keefe, I don't have plans with them. She just said they're headed out in a bit and will text when they land somewhere. 6:39:52 p.m. on the 28th. From the defendant to John O'Keefe, if you want to go out with Mike solo, that's fine. Just let me know. 6:40:17 p.m. on the 28th. From John O'Keefe to the defendant, I already told you what you should do. Not going to keep doing this. 6:41:07 p.m. on the 28th. From the defendant to John O'Keefe, I asked to let me know if you guys are going to head out. I haven't been out for drinks this week and had a shit week and a shit day. And I dread Kaylee or Pat is going to get chatty with me the second I walk in, and that is going to irritate you. 6:43:21 on the 28th. From John O'Keefe to the defendant, Pat is leaving. Kay is with Mad Cam. 6:44:02 p.m. on the 28th. John O'Keefe to the defendant, I'll text Chris then. 6:46:44 p.m.
It's got to end soon. They're going to the bar soon.
John O'Keefe to the defendant, we're headed out shortly. What's your plan, Karen? 7:06:13 p.m. on the 28th. From the defendant to John O'Keefe, do you want to join? Do you want me to join or no? 7:06:37 p.m. on the 28th.
Tell me you want me.
From John O'Keefe to the defendant,
don't you want me?
Yes, wasn't sure.
You know I'll
if you were
drive my
meeting
Lexus
the
when you
currents.
say that you don't need me.
7:07:04 p.m. on the 28th. From the defendant to John O'Keefe, they are not out drinking yet. 7:07:40 p.m. on the 28th. From the defendant to John O'Keefe, where are you headed? 7:09:22 p.m. on the 28th. John O'Keefe to the defendant, trying to decide maybe McCarthy's. 7:14:48 p.m. on the 28th. From the defendant to John O'Keefe, okay then, let me know where you decide. I'm still down in Enfield. 7:21:50 p.m. on the 28th. From John O'Keefe to the defendant, text me when you leave. Still waiting on McKinney's. 7:22:28 p.m. on the 28th. From the defendant to John O'Keefe, I'm having issues with my hot water, so had to text someone to take a look. 7:24:11 p.m. on the 28th. John O'Keefe to the defendant, an emoji, you trying to piss me off. 7:25:35 on the 28th. John O'Keefe to the defendant, hope your plumber buddy that you texted is hot. 7:26:24 p.m. on the 28th. From the defendant to John O'Keefe, nope, my shower only got lukewarm and now my sink won't run hot at all. The plumber I used is right down the road. 7:26:27 p.m. on the 28th. From the defendant to John O'Keefe, I turned that temp thing in the basement all the way up. 7:26:52 p.m. on the 28th.
Like the temperature of this relationship.
John O'Keefe to the defendant, check the hot water heater and see if it's leaking. 7:26:52 p.m. on the 28th. The defendant to John O'Keefe, it's not. 7:26:59 p.m. on the 28th. John O'Keefe to the defendant, don't do that. 7:27:01 p.m. on the 28th. John O'Keefe to the defendant, is the pilot lit? 7:27:08 p.m. on the 28th.
He's trying to be so helpful.
Depending on the
defendant to
context,
John
is
O'Keefe,
the pilot
I was
lit?
trying to get my
There's a lot of
shower
different
hot.
meanings.
7:27:12 p.m.
Trying to
on the
get
28th.
something hot.
The defendant, John O'Keefe, yes. 7:27:14 p.m. on the 28th.
Now she's with a plumber and a pilot.
From John O'Keefe to the defendant, don't turn it up. Don't turn it all the way up. 7:27:26 p.m. on the
75% of the way up.
John O'Keefe to the defendant, it will burn out. 7:27:32 p.m. on the 28th. From the defendant to John O'Keefe, I had this issue twice before and it wasn't a disaster. I just can't remember what the cause was. 7:27:41 on the 28th.
Lack of a man.
From John O'Keefe to the defendant, just turn it back to where it was and get over here. 7:28:08 p.m. on the 28th.
Is the pilot light out at this
From the
point?
defendant to John O'Keefe, I don't want to come home in a blizzard and then really be up shit creek. 7:28:53 p.m. on the 28th.
That text was
John
not
O'Keefe
did not
to the
turn out
defendant.
well.
So you're going home tonight, 7:29:18 p.m. on the 28th.
I hope not.
From the defendant to John O'Keefe, or tomorrow or whenever. I've had a chill all day since my shower. 7:29:45 p.m. on the 28th. From John O'Keefe to the defendant, it's going to snow all day tomorrow. No driving. 7:30:05 p.m. on the 28th. From John O'Keefe to the defendant, we're headed to McCarthy's. 7:41:29 p.m. on the 28th. From the defendant to John O'Keefe, okay, let me know if you end up leaving. 7:41:57 p.m. on the 28th. From John O'Keefe to the defendant, why? Now you're not coming. 7:42:27 p.m. on the 28th. From the defendant to John O'Keefe, I'm waiting for the plumber. I actually think he's in the driveway. 7:42:56 p.m. on the 28th. From John O'Keefe to the defendant, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. 7:43:10 p.m. on the 28th. From the defendant to John O'Keefe, he's not going home after. 7:43:27 p.m. on the 28th. John O'Keefe to the defendant, 8 o'clock on a Friday, emoji, 7:43:31 p.m. on the 28th.
Winky face.
John O'Keefe to the defendant, he may have to get Michael, 7:43:46 p.m. on the 28th.
What was 8 o'clock? They're drinking at 8 o'clock on a Friday?
Yeah,
Or
now
the-
they're
John
drinking.
O'Keefe to the defendant,
The mood's
you have
getting
a plumber
better.
coming over at 8. Knowing me and Papa could have handled it. Good luck.
Whoa,
7:44:36 p.m.
She is
on
a
the
plumber
28th.
coming over at 8 on a Friday?
From the defendant to
Clean
John
them
O'Keefe,
pipes?
I have always told you I will not put either of you out of your way the way everyone else in your life does. I knew it wasn't working right when you were at the doctor's with Kaylee, and I knew neither of you could get here. And this guy, Richie, fixed it last time, whatever it was. He was supposed to be here at 5, 7:48:01 p.m. on the 28th.
So Richie fixed her plumbing last time when John
From the
wasn't
defense of
around.
John
Now
O'Keefe,
Richie's
if it's not a
fixing it
quick
again
fix, I'll
8
tell
on
him
a
to forget
Friday.
it. 7:48:20 p.m. on the 28th.
Oh.
John O'Keefe to the defendant, if you need a new water heater, don't let him do it.
Yeah, it'll be like $5,000.
7:54
We're
p.m.
in different
on the
places
28th.
here. True. The problems with these
Defendant
texts.
is from the defendant to John O'Keefe. He's here now. If it's not quick, I'm not doing it. I just want to make sure nothing is wrong / will go wrong with when I'm not home. 7:55:44 on the 28th. From the defendant to John O'Keefe, he's not a scammer. Half the quick stuff he doesn't even charge me for.
Just a quickie. The quickies are free.
7:56:06 p.m. on the 28th.
He's really good at laying pipe at 8 on a Friday.
The defendant to John O'Keefe, he just put the toilet seats on crooked. 7:56:28 p.m. on the 28th. John O'Keefe to the defendant, status,
Wreck.
8:09:02 p.m. on the 28th.
Sated.
From the defendant to John O'Keefe, still
Oh
here
no,
with
Rich,
an
he's
emoji.
not putting it down today.
8:09:18 p.m. on the 28th.
Still here.
From the defendant to John O'Keefe, said he's got to go to HD and probably be back mañana. 8:23:56 p.m. on the 28th.
Mañana if you don't mean.
John O'Keefe to the defendant, so 8:24:43 p.m. on the 28th. From the defendant to John O'Keefe, an emoji, 8:25:02 p.m. on the 28th.
What's that mean?
It's like a, I don't
From
know.
the defendant to John O'Keefe,
Shrug.
just trying to figure out if I need to be here. 8:25:51 p.m. on the 28th.
Emojis are a disaster because they don't actually necessarily say what they
John
are.
O'Keefe to the defendant, what does it need? 8:26:01 p.m. on the 28th. From the defendant to John O'Keefe, I don't know. He showed me some pieces that was all rusted. An emoji. I don't understand half this
Rusty
stuff.
trombone.
8:26:42 p.m. on the 28th. John O'Keefe to the defendant on the water heater.
Say my shower
8:26:59
texts are
p.m.
bad.
on the 28th.
It was his zipper.
From the defendant to John O'Keefe, yes, 8:27:08 p.m. on the 28th. From John O'Keefe to the defendant, tell him to leave it. I'll take care of it Sunday or Monday. 8:28:30 p.m. on the 28th.
You can have a hot shower in 30
From the defendant to John
days.
O'Keefe, no, it's okay. I can either meet him here or just shut off the alarm. 8:28:52 p.m. on the 28th. From the defendant to John O'Keefe, he used to work here while I was at work. 8:29:02 p.m. on the 28th. From John O'Keefe to the defendant, does he realize it will be whiteout conditions tomorrow a.m.? 8:29:32 p.m. on the 28th.
I have
From
so
the
many
defendant to John
inappropriate
O'Keefe,
jokes.
yeah, but he lives right down the road. 8:29:47 p.m. on the 28th.
Richie's here all the time, actually.
From John O'Keefe to the defendant, Karen, the storm is going to be intense. Can't drive.
I might bury
8:19
someone.
p.m. on the 28th.
She'll
From the
show him who
defendant
can
to John
drive.
O'Keefe, okay, well, if he can't, he can't. 8:36 p.m. on the 28th. John O'Keefe to the defendant, I'll do it Monday. 8:56 p.m. on the 28th. From the defendant to John O'Keefe, I better not still have this problem on Monday. 8:31:22 p.m. on the 28th. From John O'Keefe to the defendant, you plan on being there. 8:31:43 p.m. on the 28th.
Oh, come on.
From the defendant to John O'Keefe, I'd to know I can take a hot shower there here if I need to. 8:32:14 p.m.
Just take a
on the
hot shower at
28th.
John's house. You're going to stay the night anyway.
Figured you'd be, from John O'Keefe to the defendant, figured you'd be in Canton until Monday. 8:32:32 p.m. on the 28th. From John O'Keefe to the defendant, I'm getting off my phone. Let me know what you're doing.
The whole thing's like
8:32:54 p.m.
like the Notebook.
From the defendant to John O'Keefe, I think the four of us together is toxic to this relationship. Would like to limit it. 8:33:16 p.m. on the 28th. From the defendant to John O'Keefe, you said so yourself for probably a year now. 8:33:52 p.m. on the 28th. John O'Keefe to the defendant, blizzard tomorrow. Nobody is going anywhere. 8:33:56 p.m. on the 28th. From the defendant to John O'Keefe, maybe I'll come back late tonight. Bad snow is in the early a.m. 8:35:14 p.m.
Tell me you want me to stay, John. Just say it.
From the defendant to John O'Keefe, I'll head up there in a few min. Let me know if you leave. 8:35:26 p.m. on the 28th. John O'Keefe to the defendant, an emoji. He says, sure. 8:35:34 p.m.
You think he'd put up with this from a man?
That was the last of them.
Only if he's trying to bang him, probably.
We're almost done, sir.
And you can feel free to stand.
Okay, thank you, Honor.
What happened to him? Did Karen Reed hit him with a car too?
Compilation of texts,
I don't know.
messages, and phone calls between John O'Keefe,
Maybe the Jeremy Renner plow got him.
January 28, 2022.
Yes, that was.
aside from that compilation, are there other text messages and phone calls that you've reviewed between John O'Keefe and the defendant that evening, January 28, 2002, going into past midnight, January 29, 2022?
Yes, there's more text messages.
And those text messages and phone calls, are they a separate compilation from this?
Yes, that's correct.
All right, this time I'd ask us to release Trooper Guerrino and recall him at a later date.
Again?
All right, there's no objection, Mr. Alessi, correct?
No objection, subject to eventual.
Yes. All right. Thank you
I think
very
what
much,
they-
Trooper. We'll see you another time.
Thank you, Ron.
The state wants to introduce these groups of text messages or groups of
Is
messages
this the
when they're
time for me to see
relevant
counsel at
to
sidebar? Okay.
accompanying testimony, I would assume.
Yes.
So
Or
I'm going to introduce exhibit
adjacent
or clips 7 through 11.
also breaking it up is nice because the jury, will want to off themselves immediately if they have to listen to those texts for much longer. Like it's just so boring.
Thank you.
The judge seems very concerned about that guy's physical.
With the court's
comfort.
permission, could I begin with clip 7?
Yes.
Okay, clip 7. Interview 2020, September 27th.
When you walked out of the bar, how many drinks had you had?
I had probably about 4, and not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall.
And 4 drinks you felt fine to drive?
Yep.
Clip 8, please.
Okay.
Gretchen Voss.
And is the level of intoxication pretty high here for everybody?
It's happy.
Yeah.
It's
'Cause you'd had a lot to drink, right?
I wouldn't say I had like a normal amount. Let's say like a vodka.
Different for each person.
40 minutes.
Okay. And so are you feeling like buzzed? And I'm not judging, I'm just trying to get a sense. Yeah.
Clip 9, please.
The final count of my alcohol intakes, probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like old soda water with lime. Not that I need it to be a martini, but it might have had a splash of vodka in it. So I said, John, this drink tastes like it has no vodka in it. He said, just get a shot and mix it yourself. So each drink was being counted as a double. So I would get a vodka tonic and then I would pour a shot into it. So that would count as 2. Frankly, it just felt like a regular cocktail.
Yes, you're an alcoholic.
So I asked for a shot. So for my taste, it just tasted like that's the normal strength of what a drink should be. So I had maybe 2 or 3 that are being counted as 4 and 6.
This was
And
June 15th, after the
I
first
know.
trial.
Yeah.
Oh my God, she's still giving interviews.
I felt like I was buzzed. And then there was one drink, the last one that was given to me, which I would have counted as 3, but they're counting as my 6th cocktail. The guys that we were with brought around a shot.
That's because some of
and
your
they
cocktails
knew
might
that
have
I didn't
3
drink
shots in
that
them,
poured
woman.
my drink. So that's now my 5th and 6th drinks with the 7th, which is a shot that all the men did, and I poured it. So that one glass that I'm holding, that I go into the waterfall with, has 3 drinks in it, a vodka tonic and 2 shots. And which is why John said to me, you're not leaving that drink here, like you haven't touched it and just poured a bunch of vodka. He's like, just take it with you, which was something.
She's what, 125 pounds,
So then I
7
go
shots?
to Waterfall, and I put that drink down and I socialize most of the time. So that
That's
would have
a
been
lot
like
of
the
liquor.
6th and 7th drinks. Then John orders me a drink at the Waterfall that I don't drink, that he takes with him. And then there was a round of shots that Chris Howard bought that I did take. So that would have been the night. But I did not consume 9 vodka martinis or take 9 shots, depending on how you count it. And the last 2 drinks, I didn't touch.
Clip 10, please.
I mean, I'm not as clear as I would be if I hadn't been drinking. I mean, I had drank, so, and that led me to question, like, could I have hit him? Did I run over his foot or hit him in the knee? Did I incapacitate him? I mean, I always drive with my music blasting ever since I was 16. And
Stop
I know when John got out of the
talking.
car to go into Fairview, I know my car was blasting because when I got in it the next morning to go look for him, I had to immediately turn it down. And I don't know, it's stormy. I have had a few cocktails. I didn't black out, but I wasn't as lucid as I would have been if I had gone to bed at 9 and drank a tea. But so I was fuzzier than I would have been if I had had no alcohol.
Clip 11, please.
Again, after the first trial.
How did you feel after that many drinks? When you got in the car, did you feel like you could drive and did you feel I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15.
Oh, that's so funny.
I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, you know, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't have been driving. But I don't think I was driving. I know I wasn't driving recklessly. I mean, I've got plenty of video of myself driving all over the place. I put my car in John's garage, which is incredibly narrow, and I had a very oversized SUV. You see me. There's a video of me driving through the intersection when we leave Waterfall to go to Brian Albert's, and I was always taught by my father, even when you have a green light, you always should tap the brake. You don't know who's going to run a red. And I see me doing that multiple times between 12 and 1, 5 and 6
What is
a.m.
this
So
nonsense?
I know I was driving safely, not as safely or as alert as I would be if I had no alcohol. But I was not driving recklessly by any measure.
Thank you.
You tap the brake coming up on a green light?
May we approach?
Yes.
That sounds crazy. That sounds to me like someone who is juiced to the gills driving.
That's a lot. That's a lot of liquor. Look, it's one drink. It's the Long Island Iced Sea. I've had 5 of them. It's like, come on. That's a ton. You can't just call it a drink because it's in one glass.
That's like Vegas meetup levels of drinking.
Never happened.
Where's Steve Gosney?
If I don't remember it, it never happened. APP out on Steve Gosney. He's spotted next to all the sidecars. Did you say you have to step away, or the court's already back?
All right, jurors, there was some confusion with counsel regarding witnesses. So those are the witnesses for today. So
Wow.
we're done for today. Counsel assures me that
What?
won't happen again, but more importantly, we're on track. We're on schedule, not going for the rest of the day. Won't interfere with our schedule. Well, it looks like it's, I can't tell with all the curtains here, but it looks like it's a beautiful day. You'll have a nice afternoon. Tomorrow we'll be going on a view. So for that, we're comfortable clothes. We'll be walking around a little bit. We'll be going by bus, and I'll have more instructions for you tomorrow morning. But please follow those instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, read anything about this case, please disregard it and let us know. And we'll see you tomorrow morning. Remember, tomorrow's a holiday.
All rise for the court, please. Jurors, close your notebooks and follow me.
So it sounds like there may be no court tomorrow, too. I mean, they'll be having a viewing of the house, I guess.
Sure. That'll make the live stream very uninteresting. There won't be one. But that's there's some advantages to that. I've got some stuff to talk about other than the Karen Reed trial, and it'll be nice to have a little pop valve on time. Man, are they going to deal with any issues before they go though?
I don't know. We'll see.
Jury is exited the courtroom.
All right. Mr. Brennan, have you had an opportunity to think about whether experts should be permitted to either be present or watch the proceeding? And I also want to know, are you expecting to put on any expert testimony tomorrow?
Dr. Fowler will testify tomorrow. I think that should be considered expert testimony. He provides the procedures and protocol for the testing of blood serum.
Okay.
So I think he's technically considered an expert, although one of the briefer ones.
All right. Does the defense want an expert to be able to watch that? All right. So I know we've had a lot going on this morning. Do you want to address this tomorrow? When do you want to address whether experts should be present?
I can address it tomorrow morning. I can consider
All right. We'll do that. And have you talked about who you all mean? Like, do you all know who you want to have exempt from the sequestration order?
We haven't got to that detail. I'm sure they have in mind who they want. I haven't gotten to that point yet.
All right.
We can have that discussion so that we can present it tomorrow what my position is and address the court on the witnesses.
Sure, we can do that. And then I know you said that you've got an agreement that you'll provide witnesses or a list of witnesses in advance to defense counsel, and I'm sure you'll provide witnesses in advance to Mr. Brennan. Include me on that, please. I just like to know who's coming up the next day because I have to prepare as well.
Happy to. Thank you.
Okay. All right. So we'll see you tomorrow morning.
Thank you again.
All right.
All right.
Well, there we go.
It sounds like there will be testimony tomorrow. I'm not clear on when. At least one guy, Dr. Fowler, is supposed to testify about, I guess, the serum testing, the blood alcohol level of Karen Reed, which was presumably a 1.258.
That's it. Of course, this is, well, I mean, to be fair, she leaves at what, like 1, 2 in the morning, and it's 5 in the morning before they find the body, right? Like 5 to 6. So she's been digesting alcohol for quite some time, unless she kept drinking after she left. It sounds like this fight has been going on all day, but I don't know. Those text messages don't sell me on I'm going to murder you or I'm indifferent to your existence. It sounds like two people who have some of those things where you're in a relationship for a little while and frictions start to arise, especially people find like these types of things after they move in together for the first time, or there's a big life change that they're now adjusting to seeing someone new. I don't know how long ago the kids became, part of, I don't know where that timeline is, but in a different hypothetical, if someone is like, oh, I have to take care of these kids for like either a period of time or forever, now you see the person that you're dating and how they interact with kids, and you're like, holy shit, this is kind of terrifying. So maybe, those text messages strike me as people trying to work something out and being frustrated, and that they're gonna have whatever happens happen.
I can tell you exactly what's happening.
He's getting annoyed.
Today, Karen Reed is 45 years old. So a couple of years ago, 2-3 years ago, she was just over 40. She's single, over 40. She meets a guy who makes a good living. He's got a couple of his kids he's raising. They're not his own, but he's raising them as their father, as her guardian. And she comes in and she starts playing the wifey role. This guy's just looking for a girlfriend. He's just looking for somebody he can bang on the weekends. She wants more, and she knows this is her last opportunity. She's 42. She still looks pretty good. That doesn't last forever. She wants to nail this guy down, and he's not giving her the commitment she's looking for. So after a year, she starts creating drama around the kids. Well, the kids, you seem to not like it when I pay attention to the kids. He doesn't want her becoming the wife role. He's not interested in that. So they have tension there. And then she starts telling him, listen, you're not giving me all the attention I want. I want more attention from you. And one way women like this get attention is they start fights, and then they're getting attention. He just disengages from that. He's not interested in having fights all the time. So then you end up with a text exchange like this where they're going back and forth, and she's like, well, maybe I'll come out, maybe I won't, maybe I'll do this, maybe I won't. I need you, the subtext here is, I need you to say things to me that I want to hear. I want you to ask me to come out. I want you to tell me that you love me, that you care about me, all the things that would be consistent with a deeper relationship than what we currently have. And he's like, I'm not doing that. I'm not doing that. So that's what her frustration is here. But she doesn't want to lose him. She doesn't want to start over on another 2-3 year cycle with a new dude. So when she realizes she's not getting traction, then she's like, oh no, I'd be happy to come out. I'll come out. Don't worry. I'll see you there. And then when she gets there, she starts being the happy party girl. She's been her whole life, which is why she's still single at 45.
Most importantly, I don't want to deal with that. Definitely not right now. I've got my kids over. I cannot talk on the phone right now. Now, this shit has gone long enough that my dad has come over and has plopped on the couch. So now my day that I was going to spend doing this stuff has been spent answering a text message from you every 4.5 minutes. Can you give me some fucking time as a subtext? Like, we can deal with this later. Right now is not the time. And she cannot stop making that phone call. I broke up with the girl over that once. I said, if you call me again, like, I'm hanging out with my friends. I was like 16. Like, I'm hanging out with my friends. We're playing Street Fighter 2. If you call me again in the next, at all, I'm breaking up with you. And she called back like 2 minutes later. So I broke up with her. I was like, go away. I got Ryu and Ken, and we are sweeping the shit out of Blanca. So, okay, what's your big takeaway? Any big takeaway from the case today, the testimony today? Did you think anything was particularly impactful? I didn't personally find much, but
the big stuff was supposed to be the so-called argument they had over text. I don't think it's any big deal at all. I think it's totally explainable. It certainly doesn't appear to be a basis for a malicious killing of someone. It's like any relationship would be with people of these ages and these circumstances. She wants more from the relationship. She wants to nail this guy down. He's not interested. He can always get another girlfriend. He's got plenty of time. She doesn't have a lot of time. Her clock is running out. And so there's that tension there, but that's not something you kill somebody over.
Right. And none of those text messages seem, again, by your analysis, and I think it's a reasonable one, she's trying to preserve this relationship and preserve this person, this man that she's invested her time that is valuable into. Like you said, she doesn't want to start another 2 to 3 year cycle. She's looking for permanence. She thinks she's probably got it. And you can phrase and frame that however you want, depending on how you view the interplay of men and women. But at the end of the day, she's looking for something. She's got it. She's trying to hold on to it within her tolerance. And he's probably doing the same thing, but also going, I'm not moving this fast, or I'm not moving in this direction with you, whatever it may be. He may also have a side piece, right? Like there's speculation about that with the chick from yesterday, I think. But that's speculation from the chat, so I don't know.
Well, he's dated other women in the community, right? Because they talked about going by an ex-girlfriend's house or something like that. So, yeah, I mean, listen, he's a single guy who's a cop. He makes a good living as a Boston cop. Of course, he's going to be attracted to women.
Right. Yeah. And who knows, if he's dated other people, she's clearly got some suspicion, just maybe a tinge that could also be a throwaway line. Oh, so you're interested in other people? Like, he might have just said, oh, yeah, I met so-and-so. Who knows?
She's just baiting him to say, no, honey, you're the one.
Right.
You're the one for me. It's all bait. That's all.
I've never even met another woman in my life. I don't even know. I thought you were the only one around. There's just a bunch of guys walking around who wear makeup or something. I don't know.
I mean, has she been married before?
The amount I know about Karen Reed's personal life is less than my own. Karen Reed married? Was Karen Reed married before?
No.
Let's see what
it says. The AI says no. So that means she spent the last 30 years getting run through by dudes, and now she's found a nice guy.
Some of them might have walked. It's rough out there.
She's been the drunk, pretty party girl that guys have run through, and now she's finally looking for a commitment from this guy, and he's just slow walking it.
Yeah, and that's the tension, though, right? Like at first, women slow walk relationships when they're younger. They're gatekeeping. They're, you know, all of that stuff is happening there. As guys become more established and they settle into a home, a career, a reputation, etc., they become the gatekeepers. At that point, the value proposition starts to shift from one to the other. It's just kind of the interplay with how our society works out. So
And he
it's not
doesn't
even that
need a
strange.
mommy in his house. He's raising these kids already. He's been doing it for years without
How
having
old
a mother figure. 17 and 14, 17-year-old daughter, 14-year. So the time he would have needed a woman like this would have been a decade earlier. That would have been very helpful. But now the kids are practically out of the house, and the 17-year-old's gone. She's going to school. The 14-year-old's a boy. He doesn't care. He's doing sports and stuff like that. So
Yeah.
he does not need her, but she feels like she needs him.
Right. And yeah, definitely, like, these kids, he's not in a rude way. He's counting down the days till these kids that aren't his, but are his responsibility, that he has sent them on his way and he's done his job and with love and care. But now, you know, like, then he gets to retire, and that's a fine thing. And he's probably like, can you just not? Like, can you just not? Like, you can be around. I like you. But like, I'm raising these kids, so let me deal with their issues and let you and me be us. Like, just not. You don't have to, because if she comes in, starts telling them what they need to do, and it's out of character with what he said, now you've got conflict and pissed off kids, and all you want is not to have these teenagers have some reason to have a fucking mood swing.
Yeah, and also, if she's getting close to these kids to get these kids to like her, to make it problematic for him to get rid of her, that would not be cool. He wouldn't be liking that at all. Listen, you're not their mother. Don't make them feel like you're their mother, and then I can't get rid of you.
He goes, I am. It's 2025, 4, 3. When did he die? 22?
22, January 22.
Didn't even get to see Trump come back.
Yeah.
And B, how does a digital forensic specialist manage to miss 32,000 messages in a murder case? But you get to play tech wizard while sitting on enough data to light up the department. Okay, do you want to that no implication for you, because I can't imagine this happening, but can you address what happens, like, experts making mistakes? How big does the mistake have to be to disqualify the expert? Is there a mistake big enough to automatically disqualify an expert? I mean, you would think so somewhere.
You mean during testimony?
Well, this case that they're talking about, it's the.
Oh, you mean that they made a past error?
It's in a murder case where there's this guy misses 32,000 text messages in an alleged suicide, and it turns out, I believe, they determined that a cop murdered the alleged suicide. So it becomes a cop murder, and this guy missed the 32,000 text messages between the cop and the decedent.
Why would I want to disqualify? He's a state witness as the defense. I don't want him disqualified. I want him on the witness stand so I can talk about that.
Right. So there you go.
Well,
and remember, we have this guy on eventual cross.
I'm sorry, I missed you because the TV came back on for a second.
I was just saying, we have him on eventual cross. The defense, we haven't seen what the defense is planning to do to this guy. And I think that what the state wants to do is break up the monotonous reading of texts and make them relevant to some, either as a standalone piece of evidence or relevant to adjacent testimony. Here are the texts, because he just had the guy on right before that saying that they were bickering a little bit back and forth. And, you know, they're establishing the nature and level of the fighting that's going on inside this relationship. So having the text messages between those two there matters. But that guy's going to be an expert on the group text that doesn't involve those two, but involves, this other group of people later on. So they're probably going to want to isolate those messages from those chat apps in relative to that testimony.
Also, there's more text between Karen and John O'Keefe outside the house party, where she's sitting in the car. He appears to have disappeared. Now she's pissed that he hasn't come back. He's in the house drinking with his friends. So she's sending him text messages like, I imagine, like, where the F are you, you a-hole, can't believe you left me here, all that kind of stuff.
I have to step away for one more emergency. One second.
All right, I'll hit a couple super chats. Let's see. Content of character. Anyone who talks like a Bostonian, guilty. The entire court is guilty. And content of character again, another $5. Who wants a sloppy drunk as a mommy, quote unquote, for his kids, or nagging him for the next several years? The man was probably looking forward to peace and quiet. I agree. All of this to me is just her screaming for attention. Sandy Cranston, $5. Do you know that the original orders do not say not to deport to El Salvador, but say not to deport to Guatemala? You're talking about the Abrego Garcia case. Kilmar, Armando Abrego Garcia. The Guatemala is just a typo. Lawyers and judges reuse forms all the time. They don't type everything from scratch. It's fill in the blanks kind of stuff. And the form just had Guatemala from a previous use. That's all. There's nothing to it. It doesn't make any difference. Even if they meant Guatemala, what difference would it make about this case? That would just mean he didn't have a withholding of the deportation to El Salvador after all, so it was appropriate to send him. But even if he did have a withholding order, an order of withholding to El Salvador, it became null and void the moment he was designated a terrorist. Terrorists are not eligible for an order of withholding. The jury should demand a refund. A refund. Most boring movie ever. Yeah, that's why the judge spoke to the jury. They were probably nodding off and rolling their eyes. $20 from Not Cupcakes, just spreading some love. I gave that Rackets dude some cash. Here is your share. Well, that's very, very kind of you. And I'm sure that Nick enjoys his share as well. Let's see. MCE, $5. They are claiming that the passenger rear only hit John on the right side of his body when reversing. No other injuries on any side of his body. That is what they're claiming. I'm not sure I know how that worked. Well, sorry. That one is that one me too? I think so. Midnight Green, wasn't there testimony he was wearing a hoodie? So how did his arms get the lacerations? Wouldn't the sleeves also be torn? My recollection is they said a t-shirt and a light hoodie. Yeah, so I don't know what's going on with the damn with the hoodie. I guess we'll have to find out.
Yeah, the question would be, is there damage to the light hoodie? Was the light hoodie maybe slid on after someone hit their head? Although I think the testimony, or the alleged testimony from the state, will be that he never entered the house at all. Right? I think that's my understanding. In the chat, can someone help out with that? I believe the narrative of the state is that he did not, and maybe even Karen Reed didn't enter the house. But they were outside. They didn't go in, and then she left. And he was presumably going to go in, but never made it because he died. Stacy Rossi says yes. Correct. They say he didn't. Yes, and no blood on the hoodie. I mean, I don't understand if that hoodie does not have cuts in it. I don't understand how you get cuts on an arm.
Well, there'd have to be cuts no matter what the theory for the arm injury, right? So either by the dog or by the car.
Unless the hoodie was applied after the cuts.
Why would that happen?
Because one of two things. He gets in a fight. Here's my proposition. Gets in a fight, falls in, dog attacks him, falls, hits his head on the counter. He gets that wound, but he's not unconscious yet. Maybe whatever. He gets kind of stunned and dazed. He grabs his coat, goes back outside because fuck these guys, fuck the homeowner or whatever. He goes outside, passes out in the snow, dies in the snow. But then the hoodie comes on after the lacerations to the arm, after the thing, but he's got this lingering injury, and it eventually, blood pools up behind his eyes, and he passes out and dies in the snow. Again, something happens. No one even knows he dies in this scenario. They literally are dumbstruck because they think he just went outside to cool down after this fight. They're freaking out about a dog bite or whatever. This guy hit his head. As someone who has hit their head on a counter, you don't always know what happens right away, and you don't always get knocked unconscious or anything like that. It can go a whole bunch of different ways. You can have a lingering head injury that affects you a little bit later too. So the other would be he dies in the house. They put the hoodie on, no, we got to make it look like this guy never fucking came in here, and they throw him out in the yard. That would work too, I guess.
Well, I'll be interested in hearing more about this hoodie.
Yeah, me too. Well, the state's theory in general, long time though. I mean, state's going to have a couple weeks of testimony. So we've got, I got one of these things to play. These are great. These are the super tips. Again, you can do this at supertip.gg/RL and mess around with these voices like the prophet, Matthew Harris.
Hi, I'm Kurt. I'm heteroquestionable. I drink too much, and I will do anything for money. When I say anything, I mean anything. I cry myself to sleep in the corner because Nick touched me, but I liked it.
So there you go. You guys can go play around with that as much as you want. They're all much appreciated. Thank you. Megan Fox says, gotta spreads the love. Great coverage, Nick. Chat, go sign up for Nick's class, how to pee in front of burly nurses with no shame. He's not that burly. He's nice. Aaron Guano Loco Mishler says, do you think them allowing the video of Karen mocking Peggy O'Keefe could ultimately convict her? To me, it's not the video. Again, it's not the video of her mocking it. That's what the defense focused on, was how she looked. And she has a terrible face, and she makes that very, that might be her normal voice, but that like nasally Boston-y voice. And it sounds sharp and like she sounds angry. Defense focuses on how she actually looks. But to me, the more damaging thing is the consciousness of guilt argument that the prosecution put in front of the judge and the defense and did not receive an objection that was ruled on favorably for the defense. So now that goes in on close. It's less about that video and more about the prosecution being able to say, look, we have this consciousness of guilt where she is acting in a way that she knows she has done something wrong. We're showing you that with these clips that you saw earlier. Bam, bam. Here's how it works. And he already said it all in court. So they're going to say it all again, this time in front of the jury. And I think that's the most devastating part of what happened there, personally.
Yeah, and it's a very weak basis. I mean, what are the two claims for consciousness of guilt? That alleging that Karen Reed fabricated the story about the mother leaning over the kitchen island and saying it looked like John got hit by a car, and then Karen Reed picking up her own car at the O'Keefe's parents' house, picking up her own car. I mean, I don't know I've ever heard of anyone being alleged to have engaged in consciousness of guilt evidence because they fabricated a piece of testimony. Normally you just say they're lying.
It's to be clear, I don't believe there's any nexus to those two videos and consciousness of guilt in any way, but they argued it.
Yep. Right.
And the defense said, we're good with it. Yeah, very, very scary. Let's see. Here we go. Carrie says, thanks for streaming, Nick. Hey, thanks for watching, Carrie. Fat Craig says 6,000 pound Lexus. Okay, so it's full size Lexus, not a. How big is this damn Lexus? I guess it's a full size SUV. Those things, man, they get heavy. Bell Exmo says this the OFCW theory, I guess the original was that he was struck only in the arm and pinwheeled 30 feet, hitting his head at some point. I hope they call him again. So funny. But like the original
OFC,
coroner,
the officers, I guess an investigative officer. Yeah.
So he was struck in the arm and then pinwheeled 30 feet, like through the air. Again, a physics class, guys. Just one. Austin, 30 mile per hour in reverse. Think about controlling that. Well, you just go straight back, like is what you do. That's how you control that. Cheryl Fodel says curb weight of the Lexus 570 is 6,000 pounds. Thank you for clarifying. Nami says, if you base everything off just these messages, it seems like both sides are toxic and crazy.
Yes. Well, at least she is. I think he's just responding to a toxic, needy woman who's trying to passive aggressive him into giving her more emotional commitment than he's been doing.
Yeah, that's I think I agree. And they just sound tired. Like we just fought about this morning. Now you're gone. I'm with my kids. I'm done fighting about this. And then it just keeps going and just keeps going and just keeps going.
But if she wants more attention, see, for him, for the guy in this relationship, the fighting is a negative. It just consumes energy and it's
Right.
unpleasant. And it's not what he's looking for. He's looking for his life to be calm and happy and occasionally get laid. For the woman desperate for attention, the fight is the attention. She's getting the attention if he's responding. That's why she's like, why don't you call me? Why don't you get on the phone? Why can't we talk? Because she's desperate for that attention. For her, whether the attention is loving or fighting, it doesn't matter. It's attention.
Yeah, and I'm not disagreeing in any way with your analysis. I'm also adding the commentary of just how fucking tired those texts sound. Like,
Yeah, right. It's been going on for 2 years.
Come on. I'm like, we went through this earlier. I don't want to fight with you. I don't want to fight with you can mean a lot of things, but like, I don't want to fight with you. We just fought. Like, can we fucking just, it's done. Can we be done for a little bit? And like, not now. Chicken Man says, why did defense not argue Carrie's testimony impeached the first witness? Most people, we're going to address this in a minute. A lot of people don't understand what impeachment means in a trial. She stated, Karen said, did I hit him multiple times at the scene, contradicting the first witness and his bad memory? Okay, one witness doesn't impeach another witness. You impeach a witness with a prior inconsistent statement. And that impeachment is merely, it is an exception to a hearsay rule that you're offering a statement for the purposes of impeachment that otherwise would not be allowed because they said something different before and now they're saying something, something different now. That's what impeachment means, but it's not like an official thing. A judge never goes, this witness has been impeached. There's no like rule that says a witness has been impeached. The impeachment does not disqualify a witness's testimony. It doesn't strike it, and it doesn't remove the witness from being able to talk about that and anything else. It is merely going to the jury's discernment of the credibility of the witness in their own minds and nowhere else. It's really a status about the statement, not about the person speaking. And it's critical to understand that. So the defense did argue, just by calling attention to all these things, that that testimony conflicts with the first witness. But that's up to the jury to, agree with that assessment and make those connections as they're watching this trial. Hopefully that helps answer that question. Wesley, 1924 over on Rumble. Do you trust this man to save your life in an emergency? We know why it's a 6-week trial. Now that's referring back to the guy. And he also says, legal question. If someone is acquitted for murder, is it double jeopardy to later be tried for manslaughter for the same incident? To later be tried, well, if they have final resolution on the murder, then yes, it would be double jeopardy to be tried of anything of that incident. That incident is done. I guess there are very limited circumstances where something else could spring from that incident that couldn't possibly be known at the time as completely unrelated crime, right? Like some crazy theory. You charge for murder, but then they find out you that the person was in possession of child pornography. So you get acquitted of the murder, but then later find out that there was a flash drive that didn't get examined. There's child pornography on it or something that was in their pocket and recovered. And then they finally get the recovery on it. They're within the statute. I guess they could charge could they even do that? Would that be double jeopardy? That's a tough one. That's a law school question.
Newly discovered evidence. I mean, it can come into play if there's a conviction. The defense can bring, genuinely newly discovered evidence into the record on appeal. But it would have to be stuff that it would have been impossible for you to know at the time.
Right. Yeah. The circumstances would be really tough. But generally speaking, no. If you have final resolution on a circumstance, the legal jeopardy of that circumstance is resolved, and any further prosecution based on that circumstance is going to be at risk of being double jeopardy and likely will be that. Here we go. We got one of these.
From the defendant to Nick Riccietta on the 29th, want to come blow out my taillights? John is sleeping in the snow, but I've heard you have some.
These are brutal sometimes. Bell Exmo says, with my other chat, can the defense bring in the original expert and ask him about it? Yeah, I mean the defense can name a witness, an expert witness. Here's the thing though, if the defense just brings an expert and their line of questioning is, "Hey man, why were you retarded in the first trial?" Like that's not relevant to this trial. Like that doesn't help in any way because the jury's not being exposed to that witness. But if the defense believes that there's some relevant piece of testimony that that officer has, then they could bring it in. And then they could also, if they needed to, I guess they could impeach their own witness's credibility if they thought it'd be valuable. But I can't foresee the circumstance that the defense would want to bring in a guy who had an insane theory that won't be before the jury. There's just no relevance.
I don't see it. I don't see the judge allowing it, even if they wanted to. I mean, it's so tangential to this.
Well, I mean, they would have to have a specific thing that they needed from him, or like the defense found to be valuable. That was not just you made a bad prediction, like you couldn't bring in the bad testimony, except for impeachment. But you could say if there's some other fact for some reason they have, but I don't know. We're talking about getting to layers of abstraction that are hard to speculate on. Queefer Kumia get super tip Stutterland. Did the Ka had fangs and bited him? Heather Whitaker chat. Let's get Nick to 500,000 on YouTube, 200,000 on Rumble, and Law of Self-Defense to 1 million. Hey,
yes,
wait a minute.
1 million.
I think
we're getting closer. We're getting closer. We broke 1975 today. That's good. That's good on a shortened trial day. That wasn't bad.
Good job, guys.
I'd like more though. Keep subscribing. Law of Self-Defense on YouTube.
I think they're going to cap me off at 500K as a condition of probation. Rude. Welcome back, Nick. Thanks, Heather. Desert Pirate. I'm so happy to have Pope Rackets back. Thank you. Scott Christy Jones. I want to publicly say I'm glad you're back. Hey, I want to publicly say thanks. Also, Sprock Sheepy Shane. Hi, Nick. Been a while since I last watched you. Good to see you doing better. Thank you. Mephisto's movie reviews. Don't be hard on the tech cop. The 30,000 messages belong to Hillary Clinton. Boxfort defendant. Don't forget to congratulate Uncivil for his accomplishment of reaching 118 concurrent viewers today. I always congratulate people in their efforts, so good job. Boxfort defendant. Man, you should be using that super tip voice for Daryl Brooks. He could have said it. Queefer Kumia get super tip Stutterland says he was dead already. Wounds would have bled in the hoodie. So I guess they're okay. If he's dead, depending on how much, how deep the wounds are, like he's not dying from bleeding out. So if he's dead, the heart stops pumping. These wounds aren't gonna, they're not gonna bleed on the inside of the hoodie. Yeah. Okay. I think that's what's being said here. Kevin Dorr says, Nick and Andrew, look up the Sandra Birchmore case. She was allegedly killed by a cop. All these same Canton cops and MSP cops ruled self-harm. The feds had to come in and charge him. So there you go. That's the one I was reading. Stiga says, hoodie has cuts and allegedly microscopic pieces of taillight, but was also in possession of the field trooper for 6 weeks before forensic examination.
Oh, the fire trooper, Proctor.
Yeah, the fired trooper. Now, and if I'm not mistaken, do we hear that like the hoodie also is like just sitting on the floor of the car too? Floor of the cruiser or something like that. Like it's not stored properly.
Yeah, everywhere. The hospital, the ER. I mean, they just they get his clothes off him and they just drop them. The EMS guys.
Oh, we have some shirt pics. Usually, you want to send shirtless pics. That's a joke, y'all. Here we go. Let me now see I don't know. Maybe you agree. Give me your opinion, I guess. The problem with these shirt pics is that we have testimony that they had to remove them to perform resuscitative efforts. And so these are necessarily going to have some level of compromise to them. I mean, we're going to see you can see right here, right? Like there's cuts right up the thing where they had to remove the hoodie, right? I would think.
And then they cut the length of the sleeve.
Right. Yeah. Cause they cut it up here. They cut the length of the sleeve and they got to get to your chest and skin. If they're going to apply a AED paddle, they have to examine your torso to see if you have any critical injuries to the main part of your body that's working. so that's gonna be a tough one. It's hard to tell from that. Here's the back of it. They cut down the sides of the shirt as well. They're just getting this thing off of the body. So wait here. Oh, so that's his shirt. Here's the hoodie, I guess. But it's same story. Like they got to chop this thing off of him. So that, down the torso, down the arms.
So it's the right arm, right? So where's
Yeah,
all
so-
the the shredding of the right arm, right? We have the one big cut that they do with those EMS scissors.
Yeah,
to
obviously
get it off him.
scissors.
But
There should be-
where's the
Remember-
shredded fabric?
There's lacerations on the arm from about here all the way up to about here. And we should see something that these are horizontal lacerations. I mean, I guess you're going to say that the glass poked in, scraped across the skin, then pulled out laterally so it didn't tear the fabric or something. But that's a stretch. It's a stretch. That wasn't the same shirt. Those are two different shirts, I think. Unless they washed the one later. I don't know. Unless they washed it. I'm very confused.
The
They said-
undershirt may not been this.
Yeah, those are two different shirts.
Yeah, right.
Clearly. So, okay, we'll stop.
Oh, wait a minute. Did they just turn it inside out?
Oh, wait. Yeah. Oh, nope. You're right. I'll take the loss on that one, guys. Thanks for making me look like an idiot. Bell Exmo says they are arguing the Bowden defense that they were incompetent. Doesn't bringing up this other theory prove they were throwing stuff at the wall? I mean, but a cop coming up with a theory that is wrong early on in an investigation is throwing stuff. Cops throw stuff at the wall. Like, maybe it's this, maybe it's this, maybe it's this. We don't know how this guy is dead in the snow. I don't know. Maybe she backed into him and knocked him 30 feet away. He was running after her. Like, some guy throws it out and then he has to testify. Hey, did you say this really stupid thing? Look, it's 5 a.m. But yeah, so we'll have to see it again. I can't figure out why they'd call him. SVH says, is the chat technically participating in legal analysis? I watched some review Fox's letter and that's not supposed to happen. No, we don't do that here. Only jokes about genitalia. Junebug Tower says, I'm giving you a second chance, Nick. Hope you and your family get better. Bye and take care. Hey, thank you. I appreciate that. We'll try. And then I've got one from Miscellaneous, and I think I'm about done. Someone needs to recreate the Goodfellas Karen and Henry Hill bedroom gun scene using Karen Reed's face. Put it into Chat GPT and see what it comes up with. Kind of like my thumbnails. Oh,
Here's
my
one
gosh.
for me. Content of character, $5. Was she driving a monster truck? How high were her taillights? Yeah, we brought that up yesterday. Are they shoulder high? Was he supposed to be bent over when she hit him?
Yeah, and the bend, if he's bent horizontally, that crushes the taillight direction of lacerations on the arm. I mean, how do you get horizontal lacerations on the arm if you are at a 90-degree angle to the ground, which would put your head down where the taillight could hit you, or where the car could hit you, but that's going to make scrapes that go this way unless you're. The ways that this body has to Mr. Bill or Gumby its way into shape to form this theory is messy. Lefty's Gaming Lulz, great to see you back, Nick. Hey, thank you. Great to be back. Well, man, that's my super chats and everything that I've got.
Let me see if I have anything I need to address from my Law Self-Defense members. Yeah, okay, there are some. Paul from Florida says passive-aggressive mental blackmail. That's how I read that dispute too, between Karen Dean and John O'Keefe. Let's see. Paul in Florida says this chick must have something major to offer because she's way too much work. Should have given her the boot to the curb long ago. You can tell when we get into my chat. Let's see. I just had to read all those texts. Yeah.
Oh man.
I was someone I made up a blood alcohol level 1.258. That's not a thing, folks.
Oh, I thought that was real.
You know, somebody says, "Holy cow, talk about hammered." No, you can't get to that. I did work a case where the guy
Oh, I
who
thought
was
you
killed.
said 0.125.
No, I
Yep.
said 1.2.
I thought you said 0.12. My brain just
you have no blood. You're running on vodka.
I've
But I did
tried.
work a case where the murder victim, well, he wasn't murdered. It was self-defense. Sorry. The person justifiably killed.
She was a
at-
0.093 official, or well, that's the
next morning.
testimony. Yeah.
But the dead guy on the case I worked on, his blood alcohol was 0.43.
Oh my God.
0.43. 0.08 is drunk driving. So he was 5 times over the legal limit for drunk driving, and he still picked the fight with somebody and got himself killed.
0.08 is drunk driving. 0.43 is drunk living.
Kevin, law self-defense member Kevin said, "I had no idea
Ooh.
Andrew knew the female mind that well." Oh, yes, sir. Yes,
You
sir.
will learn that this man.
It's been a long, hard road. A long, hard road. This
Okay, hold
I'm
on, I've-
speaking from experience.
I've got holes in my hoodie, the country song. I'm just kidding. Here's a close up of some of the holes that are alleged from the. So here we've got. So we're talking 1.5 centimeters to 2 centimeters. Looks like on this this hole in the sleeve. Here we go. A 1 centimeter. Are these centimeters? Yeah, these are centimeters. So 1 centimeter. I would imagine a 1 centimeter hole in this sleeve, I guess. Looks like there's another one down here that would be about the same size. I don't know if this is a different one or the same one. We'll see. 199. So there's 197, 211, 199. We have another one. This is 2 to 2.5 centimeters. It looks like we also, or I don't know if we're looking at that one or this very small one's about 1/4 centimeter.
They don't look right to me. Those puffy edges on the fabric, it doesn't look to me like whatever caused those lacerations in John O'Keefe's arm caused this. This looks like a different cause to me.
This looks like a bullet coming out of the sleeve.
I mean,
It just-
if you cut this with a razor, like you would get slashing marks on an arm, you don't get these fuzzy edges in the fabric.
Brian, you're a guy who has probably seen tons of knife wounds and the effects of knives and other sharp objects on clothing of all various types in the cases that you've worked with, right?
I have.
So I'll trust your judgment on it. I mean, to me, it looks like rips in a hoodie, which could be from any number of things. Like some people like to wear an old hoodie.
This
Right?
guy is a
Go through a
cop
lot.
who's willing to put in his girlfriend's new hot water heater, right? So he handles stuff like that. He's going to have clothes that are beat up. Anyone who does that kind of work has clothes that are beat up because they get damaged by the work.
Right. And people are saying looks like puncture wounds from a dog. I mean, I don't know that I fully agree with that either. I'm like, these are big holes and they're kind of spaced out pretty far. Like where the other teeth, where the other rips is his dog grabbing and ripping and like trying to shake the fabric. I don't know. It could just be a beat up hoodie. Like you just said. I mean, this is a guy who fixes stuff on his own. He's not just going out and buying a new hoodie every time. Maybe this is a drinking hoodie. I don't know what he does. Branca wears this overshirt quite frequently on live streams, right? Like you get a couple holes in on the back of it or something like that where it's not on camera. Are you gonna just trade it in and go grab another one? I mean, maybe, but also why?
I mean, I have clothes I keep as work clothes. If I have to do something on the car or around the house, I put those on. It's because they get beat up. They get paint on them. They get blood on them. They get, chlorine from the hot tub gets on it and discolors it. It's just what you do.
Imagine wearing clothes in a hot tub. That's a joke. All right. Well, I mean, unless you've got anything else, we get to end right here before lunch today. You take a little breather, guys.
That's
I might.
good.
I think the person who is calling me their crisis is about as handled as it can be for a while. That's not a fun situation, but so it sounds like I'll just be able to take care of some stuff around the house. But I'll probably end up doing another stream later or working on some videos. So this is a blessing, and now I have to figure out the rest of my day.
So someone on my chat sent me a news article that purports to have a witness list for the state. So I just texted you that. If you want to take a look at it, I don't trust anything journalists say, so who knows if it's made up, but just as kind of background. All right, folks. Well, the only thing I want to mention, I guess, is one last time, because it's happening in 2 days, and that is our my Law of Self-Defense advanced class that I'm teaching on Saturday, this Saturday, April 26th, the full day class on how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property, all in plain English, taught live by me. If you can't make it on Saturday, if you have a conflict, register anyway, because we make the recording of the class available to all the students for a full 2 weeks after the live class, so you can watch it at your leisure during that time. I only teach this class twice a year, so if you miss this one, it'll be at least 6 months before I do it again. Don't do that. Don't miss it. Sign up now at lawofselfdefense.com/advanced. It's not expensive, and it'll teach you a lot.
Guys, sign up for the class. What else are you doing Saturday? You know what you're not doing? If you're not in the class, you're not learning how to protect yourself. You're not getting hard. You're not getting hard to convict, and you're probably going to prison for the rest of your life. Thanks. Good job. Good job. And even I stumbled out of that one. So, well, man, it's always a pleasure. All right. I gotta figure out how to get these messages, the text ones, off of here without playing something else. But anyway, it's always a pleasure. We'll see you tomorrow.
Do you have a sense of what's actually going on tomorrow with this court? Like, what time are they doing this viewing of the crime scene in the morning and then live streaming later in the day?
I don't know. I'll try and poke around. If I see anything, I'll message you. And hopefully once we figure it out, we can set up a live stream and announce it out so that people know where they can find us and when we will start. I mean, maybe they're only going to be gone for like the first hour. We can just sit around, bullshit or whatever, or talk about the case or recap anything. Maybe there's some moment we want to go back to and talk about. I don't know. Or I should say, maybe there's some moment the chat would want to go back to. They said they'd send a super chat or something, and they say, hey, can you go look at timestamp of this at this link and talk to us about what happened here? Maybe if we have some downtime in the case for something like them to go visit a crime scene, we could try out stuff like that too. Who knows?
Maybe some of those interviews she did, those might be fun laughing at.
She's got crazy AOC eyes, which I think is we could probably redo that Betty Davis eyes song, except with crazy AOC eyes or whatever. But in those interviews, that's one of the problems. She does look a little bit unhinged. I mean, and you can understand why. She's fighting for her fucking life. Like, there are reasons, but man, just it's murder. Don't do them.
But you can just see her. I mean, in those interviews, you look at her, you hear her, and you think to yourself, you know what? I can see her speeding her car backwards into her boyfriend if she's having a fit of outrage in the moment. And she'll be totally sorry about it 3 minutes later. But in that moment, she's stomping on that gas pedal. She's mad, and everyone's going to know it. And she's been drinking. She's juiced to the gills. That's not how you don't want the jury to see your guilt as a very possible vision.
Right. And the drinking, take it from an expert. She's used to the gills. That exacerbates her emotional state from before. And I'm not talking about malice, and I'm not talking about indifference towards John O'Keefe. It's just bad decision-making that's being amplified by what's going on. I mean, she gets into a car and drives drunk right then. She didn't hit John. She's really lucky she didn't plow into someone else. It's just the time of night. There's not as many people outside. But she easily could have run over someone walking their dog late at night or something. Who knows? Although it's a blizzard, I guess.
And the alcohol tends to amplify people's personalities anyway. So if she's already inclined to drama and getting into fights with her boyfriend because she gets her attention, she likes the fight. So she likes being angry in the moment because she can always make up with them later. Well, she has 9 drinks. She's going to be even more inclined to that.
Right. And again, take this from someone with a ton of experience in that field. It's whole, except for the whole driving drunk thing. Like, that's insane to me. It's just not that bothers me. But here we go. I got one more of these things, and then I'm ready to roll out.
Hey, Nick and Branca, this is a question to the comments you made yesterday that you want your client and witnesses to appear homely. What
No,
if
I
they
want
are
yours
a
to be
Gyaru,
homely.
especially a well-endowed one? Now, what if they are also your childhood friend who teases and bullies you since forever? Also, what do you do if they are also an expert on the Federal Unemployment Tax Act, especially the 34th rule? I should also mention that they are not an expert on the balls, short for bureaucrats and lawyers' legal services section of the act. I'm asking because I have a trial coming up and need answers. They said they're going to put a cage on me if I screw this trial up. Send help, please.
Well, brother, unfortunately, my license is temporarily suspended, so I cannot offer you legal advice in this situation. But sounds like a balls or no balls question to me. Always, always team balls. All right, man.
All right, Guy. Let me know later on what's going on. Everybody else, we look forward to seeing you at some time tomorrow. You'll know when we know because we'll post up a live stream ahead of time. We'll schedule it so you can have a sense of what's going on. You'll find it either at lawofselfdefense.com, well, Law of Self-Defense on YouTube, or on Nick's Ricardo Law YouTube channel or Rumble channel. And we'll see you all then. Take care, brother. Bye-bye.
All right, guys. YouTube. Yep. See you later.